Good morning. We're going to go ahead and call to order this September 19th meeting of the Cannabis Compliance Board. If we could go ahead and have a roll call.
Thank you, Chair. Roll call. Vice Chair Durrett.
Here.
Justice Douglas.
Here.
Member Merritt.
Present.
Dr. Mazarana.
Here.
And Chair Guzman Freyler.
Here. Thank you and welcome everybody. I want to go ahead and open up public comment. We'll start in the south. Then we'll go up to the north, and then we'll also have public comment on the internet, and we'll have some instructions for that right now.
To provide public comment via telephone, call 669-444-9171. Enter webinar ID 880-5937-7845, followed by passcode 417578.
Thank you. With that, we'll go down in the south and have public comment. We'll have two public comments, one right now, and then we'll have one at the end. But also remember that each item, depending on what it is, might be public comment. So if there is something on the agenda that we might have a lot of public comment for, you might want to wait until that actual item comes up. So with that, there's a reminder that our public comment is limited to 3 minutes. We have a full agenda and some controversial items on the agenda. So I would appreciate keeping your comments to a minimum. And with that, welcome the South public comment.
May I proceed? Okay. Good morning, Madam Chair, members of the board. My name is Pui Premseret, bar number 7141520 South 4th Street. I'm here on behalf of Mesa Oils and Redwood Cultivation, also licensees governed by this board. My clients provided product to MedMen. This is in relation to agenda item 5D. My clients are judgment creditors of the MedMen dispensaries. They supplied product to those dispensaries to the tune of $250,000. We've procured judgments against those dispensaries and have endured post-judgment collections, case number A880833. We sought a writ of attachment to which the CCB approval was required. We've also filed a motion to enjoin the transfer of these licenses. That was filed September 10th. In response to that, we learned of a California receivership, which was instituted June of 2024. That receivership only extends to the territorial limits of LA County and does not come into the state of Nevada. We believe that MedMen is advancing this receivership before the board without approval. More importantly, senior lenders are reporting to have a security interest in these dispensaries, which we think also runs afoul of the CCB approval requirement. Jurisdictionally, the California receivership has no business here pursuant to U.S. Supreme Court Booth v. Clark. Also, they cannot control the disposition of these dispensaries. And by not having sought approval from you pursuant to NCCR 4.041A6, as well as NCCR 5.110 sub 1 and sub 4 respectively, we believe that these licenses should not be transferred at this time. At a minimum, the court has set our hearing to enjoin the transfer of these licenses on order shortening time scheduled to be heard September 24th, which is next week. At a minimum, we would ask for agenda item 5D to be postponed to such time as the court can exercise jurisdiction and hear these matters. And I would like to be heard when that item is called, if the board would so permit me to do so. Thank you.
Thank you very much. And we will discuss that item when it comes up and give you an opportunity to speak on that, as well as have the board members ask any questions that they might have.
Thank you, Madam Chair.
Additional public comment in the South, please state your name for the record.
Good morning, everyone. My name is Tara Baker. I'm here on behalf of Eco Weed Disposal Solutions, and I'm just coming to give my monthly update that we're good to go. I'm up, I'm ready. So if anybody needs any assistance with any cannabis waste destruction, please give me a call. Thank you.
Thank you.
Hi, everyone. My name's Shanna Perry, for the record. My brand is Cannabis. I know some of you, I've been an advocate in this town since 2015. Before that, since about 2012 nationally. Before that, before I throw this out here, I've got copies for everyone. This is just some edits to the lounge licensing. I have been part of creating cannabis for a really long time. And the process of which, if you're going to serve it, if you're going to use it as a infused product, if you're going to use it as an infused product for meals, which is what the variable of this license is allowing these businesses to do. And if you don't have the proper supply chain, such as infused coconut oil, things like that to make these things. I'm not going to go through all of these, but I really don't understand exactly what a ready to consume product is versus a regular product you would buy from a dispensary, ready to consume versus single use. Also, a lot of the requirements that you're asking here, I don't know if you guys are familiar with what a hot box is or what hot boxing is, but it's when you encase everybody in clouds of smoke of marijuana and they get extra high, which can cause an over consumption like instantly. And by you guys having up all these partitions, you're causing that to happen. So another thing too that I found a little disturbing is that if you do allocate these licenses to businesses under the presumption that they're going to be able to monetize things like infused meals, if they're not doing that infusion by getting a pound and cooking it down in a kitchen, they're not infusing anything. And then you have to test that before you serve it. And you can't guarantee how much one portion of mashed potatoes is to another portion. So this as a business is terrible. Not to mention that if we go back to the dram shop law, which protects alcohol companies from litigation and lawsuit, there's no protection here. We've got legislature next coming up right along here. I think the two main things that have to happen is there needs to be protections for anybody serving in this industry. There needs to be allocation for massive distribution. Otherwise, I don't believe a lot of these companies will be here next year. And you guys made this license for a lounge, and I was yelling at the TV in another state 2 years ago, because there's so many other businesses and cannabis is, if anybody in here thinks, and I put on here, I'm like, you're kind of crazy. If anybody in here thinks that anybody's going to generate revenue from a catering service, a lounge, a med spa, an infused restaurant, special promotions, any more than one or two partners being able to make a decent life and pay some good employees, everybody's nuts. So like, it's not realistic. Having permits for a few $100s a year, just like an Uber driver or any other business, makes sense. We're adding cannabis. If I have a spa, I want to be able to get product at a wholesale price, bring it in and use it on my clients. And this is the future. And either we're innovative into this cannabis and moving forward, or we're stalemate and we're not going to dominate. And we're Las Vegas, we should. So anyway, my name is Cannabis. Nice to see you. Nice to meet you. Thank you for your time.
Thank you. Any additional public comment in the south? Okay. I don't see anybody approaching, so we'll go ahead and go to the north. Is there any public comment in the north? We don't have any public comment up here. How about online?
If you wish to provide public comment, dial *9 to raise your hand if joining by phone, or click the raise hand icon if joining via Zoom. There is no online comment.
Thank you. With that, we'll go on to item number 2, which is the approval of the meeting minutes. This is approval of the August 15th, 2024 Cannabis Compliance Board meeting minutes. Having had the opportunity to review the minutes, if anyone has any comments, concerns, or edits, this would be the time to state so. Otherwise, I'll take a motion for the approval of the August 15th, 2024 minutes.
Member Douglas, for the record, move to approve.
We have a motion. Is there a second?
Member Durrett, I second.
Thank you, Member Durrett. We have a first and second. Any discussion on the motion? Hearing none. All those in favor say aye. Aye.
Aye.
Any opposed? Okay, motion carries. Now we go on to item number 3, which is our consent agenda. Our consent agenda may be voted on in one fell swoop, or we could have items pulled. We've got 3 items under this consent agenda, which is the approval of extension of final inspection deadlines, complaints, and consideration of approval of a waiver, which is a housekeeping measure. Are we pulling any items, board members?
Member Douglas, for the record, under item A, I asked to consider separately items 10 and 11, Nevada Pure LLC and FCWC.
Perfect. Any additional items to be pulled from the consent agenda? Okay, then I'm prepared to take a motion on the approval of consent agenda item A, items 1, 2, 3, 4, 5, 6, 7, 8, 9, 12, 13, 14, 15, 16, and items B and C. Is there a motion?
Member Mazzarano makes a motion to approve the above items. And I believe the date for the extension would be December 1st, 2025.
Is there a second?
Member Drat, I second.
Okay, all those, is there any discussion on the motion? Hearing none, all those in favor say aye. Aye.
Aye.
Any opposed? Motion carries. And we'll go ahead and start with the items that were taken out of the consent agenda, starting with item number 10. And we'll go ahead and have Chief Gilbert. This is item number 10, which is Nevada Pure LLC.
Madam Chair, if I could, Member Douglas, for the record, if I could shorten that up, let me do that. I'm not opposed to either one of them, 10 or 11, being approved, but in order to make the statement I want to make, I could not do it under the consent agenda.
Understood.
And that is, these two both are on because they're having financial difficulty securing necessary funds to do build out and so on their project. They've had one extension thus far. We've talked about previously the need to set some finality as to extensions of time for initial licenses. By code, it's 12 months, but it says the board at its discretion can continue. We need to set some parameters as to why we should continue or not continue a license that hasn't really opened its doors. That's the only comment I would ask staff to look to have either some kind of workshops or put this back on so we can talk about this. That's my only reason for having those 2 items pulled.
Thank you. And do we have any comment from council as to how we would go about doing that, or will we just see an agenda item on a future agenda?
Yeah, that'll probably work. Just put it on a future agenda. Maybe vote on it, though.
Well, I'll ask today to approve these 2 items, but the purpose for the discussion based on conversation about consent items, I could not comment about my request to have a discussion as to looking for some guidance as to giving continuances of license applications.
Okay.
I don't quite understand.
I mean, they could be referred to staff and put on another agenda later. That would be my suggestion.
And yeah,
Okay. And as for these 2 items, then,
and with that, I'd make a motion for approval of the 2 items, but I just wanted to make the comment that we've had this discussion or lack of discussion about extensions and when we stop giving extensions.
Okay. And would that be for extension to December 1st, 2025 as the others?
Yes, it would be.
Okay, we have a motion. Is there a second?
Member Grant, I second.
Any discussion on the motion? All those in favor say aye. Aye.
Aye.
Aye.
Any opposed? Motion carries. And with that, we are done with item number 3. We'll go ahead and go on to item number 4. This is a new process with regard to certificate of qualification for a cannabis receiver. In the past, we have seen every time there is a receiver to be approved, they come before us, we look at their qualifications and we rule on that. And with regard to this process, under Regulation 5, we have a new process, and I can have Chief Gilbert explain a little bit about that. We have before us Kevin Singer for a certificate of qualification for cannabis receiver under item 4A.
Thank you, Chair. Good morning to you and members of the board. Steve Gilbert, Chief of Administration for the record. Agenda item 4 consists of an application of Mr. Singer's requirements for a certificate of qualification for a cannabis receiver pursuant to NCCR 5.195. The board has approved Mr. Singer as a cannabis receiver over multiple Nevada cannabis establishments over the past several years. Mr. Singer is currently serving as a court-appointed and CCB-approved cannabis receiver over the following Nevada establishments: the Harvest Foundation, LLC, Greenleaf Farms Holdings, LLC, the Hempire Company, LLC, and MJ Distributing, LLC. In addition, Mr. Singer has successfully completed his cannabis receivership duties for 2 other Nevada cannabis establishments. To apply for a certificate of qualification, Mr. Singer supplied the information which is set forth in NCCR 5.195. Given Mr. Singer's history and ongoing work as a Nevada cannabis receiver, there are no concerns regarding approval of his application for a certificate of qualification for a cannabis receiver. It appears Mr. Singer is qualified to be awarded a certificate of qualification for a cannabis receiver. Mr. Singer will be available for any questions if the board has any questions for him.
Okay, thank you so much. So with that, welcome, Mr. Singer.
Thank you.
And we're happy to see this new process. I'm sure that you're happy that you won't have to see us as much.
No, I enjoy coming here and enjoy being part of the process.
Okay, do the board members have any questions for Mr. Singer or the process that we are going through at this time for the very first time for our board? So if I could have, just for the public, if I could have either council or Mr. Gilbert just kind of explain how this would work. We know that Mr. Singer is qualified for this certificate. So now we have the certificate on file. And so how would that process work if we have a licensee who is going to go into receivership before we would have that item placed on our agenda and we would have the receiver come before us and we would approve the credentials or the receiver for that particular receivership. But how does that differ this time now having that certificate?
Chair, I can address that. Christopher Rath, Senior Deputy Attorney General for the record. So under the certificate of qualification system, if you approve a certificate of qualification and a cannabis receiver has received a certificate of qualification, then when the cannabis receiver wants to apply for a specific location, the cannabis receiver, as usual, will submit an application for that. However, instead of having a full meeting before the board, according to NCCR 5.195 subsection 7, when that application comes in, the board shall delegate approval of the placement to the chair. And then the chair can approve that receiver for that particular cannabis establishment at the chair's discretion. However, at the chair's discretion, the chair could put the matter before, set a hearing it before the board for the application. So generally, it's going to be much quicker. The approvals are going to go through the chair unless there's something unusual and the chair wants to bring it before the entire board. So if you have any questions on that, let me know, but that's essentially the system.
Great. Thank you so much. That's going to streamline things. Any questions from the board members?
May I just comment briefly? John Savage, counsel for Kevin Singer.
Hi, Mr. Savage.
Good morning. I just wanted to bring to the board's attention and try to clarify one matter. When the application was submitted, it was submitted in a cell and specifically attached to the Red Earth cultivation license. Red Earth is a subsidiary of MJ Holdings, over which Mr. Singer was appointed in April of this year. And at the time, not called out in the order that Red Earth had a cannabis cultivation license. So when Mr. Singer was appointed, the agent card application was specific to MJ Distributing C202 LLC and MJ Distributing P133 LLC for those same license numbers. And a dispute arose during the receivership regarding whether or not Red Earth was or is a subsidiary of MJ Holdings. It was recently resolved pursuant to a stipulation order that was entered just, I guess, 2 days ago, September 17th, whereby all parties agreed that Red Earth is a wholly owned subsidiary of MJ Holdings. And so it sounds like perhaps Mr. Singer's application for an agent card over Red Earth in particular is not on the agenda for today.
Correct. I think what you'd have to do is once he has his certificate of qualification, assuming the board approves it, is just to submit another application for Red Earth because he's going to need agent cards.
Yes.
For that separate establishment, and then it can go through the expedited process if the board approves the certificate of qualification.
Okay, thank you. It's my understanding Red Earth is non-operational right now.
Okay.
So we will see how the vote goes, but presuming passes, we'll submit a separate application for the Red Earth agent card license.
Okay. So we're going to go after this. We're going to go ahead and go through the process, the expedited process.
Right. They would need to submit an application specific to Red Earth and also request an agent card for Red Earth. And then if the certificate is granted, then it would go through you and you would decide whether to approve it or set it for a hearing.
Okay, that sounds reasonable to me. Is there any issues or any concerns with that process?
Not on our end.
Okay. And Mr. Savage, on your end? Or
No
Mr. Singer?
concerns.
No concerns. I mean, I just want to take a brief moment to thank the board for putting this process together. I think it'll really help in the future in not only preventing this board from doing more work than it should have to do and having people in place who they already know are qualified and they don't have to keep going through repetitive processes to make it happen. And I just want to thank the Attorney General's office and the board for creating this process to allow both myself and the courts to have a method when there is a problem with the license to be able to take it, to market it to a broad audience of people, to find the best qualified business owner to come forward and then have a process for transferring licenses. So I just want to thank you for that. Thank you for the continued trust, and we'll keep working hard.
Just another point, if a certificate is awarded, then if the receiver applies to a court for appointment or somebody seeks appointment with him, he can certainly attach that certificate of qualification and any filings with the court.
Great. Okay, well, thank you. And with that, I'm prepared for a motion to approve the certificate of qualification for cannabis receiver for Mr. Singer.
Member Durrett, I move to approve the agenda item 4 regarding the application for certificate of qualification for Mr. Singer.
Member Mezrana seconds that.
Okay, we have first and a second. Is there any discussion on the motion? All those in favor say aye. Aye.
Aye.
Motion carries. Congratulations and thank you. I'll look for that application.
Thank you.
Okay, thank you.
Thank you. Okay, and with that, we'll go on to item number 5. These are requests for transfers of interest, and we have 4 items under this section, starting with A. Chief Staley?
Chair, could I make a disclosure on one of these? On
Absolutely.
thank you. On agenda item 5A, I'm going to abstain. As I've repeatedly said, when this item came up, before I was on the board, I was retained as an expert witness by a law firm that represented the plaintiff in an action against the defendant. So I'm going to abstain from this item out of an abundance of caution. Thank you.
Okay, and is that sufficient? I'll ask our open meeting law DAG with regard to the disclosure and abstention.
It's good.
Perfect. Okay. With that, Mr. Staley.
Chair, can you hear me okay in Reno?
Yeah. Yes, thank you.
Correct. Chair Guzman-Freilich, Vice Chair Durrett, Justice Douglas, Member Merritt, and Dr. Mazarana. For the record, I am David Staley, Division Chief of Investigations for the CCB. I'm here to present agenda item number 5, which consists of 4 transfers of interest or TOI applications. Item A are TOI applications by the Harvest Foundation, LLC. The board approved Kevin Singer as a receiver over the Harvest Foundation on September 27th, 2022. On April 19th, 2024, Singer filed TOI applications 24-00018 and 24-00019, providing for the Harvest Foundation to sell its non-operational cultivation licenses to Shubham Pandey and his company Desert Greens Uno, LLC. Pandey has been operating a dispensary in California pursuant to a management services agreement, and the Harvest Foundation cultivation licenses will represent Pandey's entrance into the Nevada market. No areas of concern were developed during this investigation. I am available for any questions, and my understanding is that Kevin Singer, John Savage, and Shubham Pandey are available to address any questions you may have as well. With that, Chair Guzman-Freilich, I'll turn this item back to you.
Thank you, Chief Staley. Do we have affirmative presentations?
Good morning, members of the board. John Savage on behalf of Kevin Singer, the receiver over the Harvest Foundation. I'd like to thank the board, staff, Mr. Rath with the AG's office, working with us to close out this long and difficult receivership appointment. Just to provide some brief background, as Mr. Staley mentioned, the receiver was appointed 2 years ago in September of 2022. And when the receiver was appointed, the licenses were suspended due to regulatory violations. So the business was non-operational and has been, could not generate any income. The company also had no cash on hand, so there's no money to pay any creditors or administrative expenses. And, but there was a transfer of interest pending with a publicly traded company, MaryMed, and the receiver tried to complete that transfer of interest. Unfortunately, did not get cooperation from MaryMed. So requested to withdraw that TOI application, and the board approved that withdrawal in January of 2023. The receiver continued the disciplinary settlement negotiations that had been ongoing, and the board ultimately approved the agreed disciplinary settlement in July of 2023. That resulted in the owners of the Harvest Foundation surrendering their agent cards with additional conditions, and the company agreeing to pay a civil penalty in the amount of $200,000. And as we worked through the sale process, the receiver determined that Mr. Pandy's offer to purchase the license for $100,000 was the highest and best offer. So we asked the board to reduce the civil penalty. And the board approved the amended disciplinary settlement in February of 2024, which reduced the civil penalty to $30,000. So again, I'd like to thank the board for being flexible with that settlement and accommodating this sale. I'd also like to thank Mr. Singer and commend him for sticking with this appointment until we finally obtained court approval for the sale in July of this year. Mr. Singer spent a lot of time, money, and energy in this appointment to preserve the licenses. And it would have been an easy one to surrender the license and ask the court to withdraw as receiver. He stuck with it. He had to come out of pocket, pay $15,000 of his own money to preserve the assets. He's owed over $100,000 in fees for the time he spent on this. So he's not going to be compensated for all this time, but it is rewarding to be able to transfer the license to a responsible owner like Mr. Pandy. And I think it's a good outcome for the state. So just like to thank everybody involved again. And unless Mr. Singer has any comments or the board has any questions, I guess we could turn it over to Mr. Pandy.
Thank you. Welcome, Mr. Pandy, and thank you for taking on this endeavor and for your entire team for making this happen.
Thank you, board members. Yeah, we're looking forward to taking this over. And I think like the staff mentioned, we do have experience in California. So a little background is I'm a CEO of a fund manager that actually runs this. We have been investing heavily in the health industry, and that's one of the big reasons why I have been trying to work on the cannabis side with the health part of it. And that is one of the big reasons why we are trying to do this process and be here. Happy to answer any questions you may have. And I guess I'll stop there for now.
Thank you. Any questions from board members? Okay, well, again, thank you so much for making this happen. This is a big win from Nevada. This is definitely what we strive to do, is to save, some of these licensee or the licenses and put people back to work and make money for the taxpayers and for the businesses and for everybody involved. So thank you very much. And any additional comments or questions from the board members? Okay. I think that's a positive sign. All right, so then we'll go ahead and get this approved. I'll take a motion.
Member Douglas, for the record, a motion for approval of transfer of interest.
Your second?
Member Mazzarano seconds that.
We have dueling seconds here.
Yes, we do.
Seconded.
Okay, Dr. Mazzarana, and any discussion on the motion? Hearing none, all those in favor say aye. Aye.
Aye.
I heard two ayes. Any opposed? Great, motion carries. Thank you.
Thank you.
Thank you. Good luck. Okay, with that, we'll go ahead and go on to item B. This is GBS Nevada Partners LLC. Chief Staley, please.
Thank you, Chair. For the record, I'm David Staley, Chief of Investigations for the CCB. Item B is a TOI application by GBS Nevada Partners LLC. TOI number 2400005 was filed requesting approval for 27.59% member Hammermeister NV LLC to divest its ownership to other existing members. GBS has also requested a waiver of NCCR 5.110 pursuant to 5.112. If approved, the requirements for prior board approval of transfers of less than 5% of GBS membership will be waived. The company has adequately addressed the items required in NCCR 5.112 and staff suggests that if approved, the board limit GBS 5.112 waiver to expire at its next TOI agenda date. No areas of concern were developed during this investigation. I am available for any questions, and my understanding is that Alicia Ashcraft, Amanda Connor, Michael Villon, James Meservy, and James Hammer are available to address any questions you may have as well. With that, Chair Guzman-Freilich, I'll turn this item back to you.
Great. Thank you very much. And thank you for being with us today. Any comments, presentations from council or the parties? There is no areas of concern. So happy to hear your presentation or your comments.
Amanda Connor with the law firm of Connor & Connor on behalf of Hammermeister, one of the entities the entity being bought out. We're here to answer any questions you may have.
And good morning, Chair Guzman-Freilich, Vice Chair Durrett, members of the board. Alicia Ashcraft, the law firm of Ashcraft & Barr on behalf of GBS Nevada Partners. With me this morning is Michael Villon, one of the remaining owners and the manager for the company. We would just like to thank and acknowledge Michael Covington, who was the CCB investigator that worked on this item. Always a pleasure to work with Michael, efficient and thorough as always. So we thank him for his efforts. And again, we're happy to answer any questions board members may have.
Great. Thank you very much. Do we have any questions from the board members? Okay. Well, then I will entertain a motion.
Member Douglas, for the record, move for approval. And also the waiver of NCCR 5.110, NCCR 5.112 until the next time this comes on for hearing.
Member Dratton, second. We have a first and a second. Any discussion on this motion? Hearing none. All those in favor say aye. Aye.
Aye.
Any opposed? Motion carries. Thank you and congratulations on the transaction.
Thank you. And I'd like to echo Alicia's comments about Investigator Covington.
Appreciate your comments. Thank you. Okay, and with that, we'll go ahead and go on to item number C, or item C. Chief Staley.
Chair Guzman-Freilich, members of the board, for the record, I'm David Staley with the CCB. Item C are TOI applications by Chalice Brands Limited. TOIs number 19064 and 19064A were filed requesting approval for APCO LLC to purchase cultivation and production licenses from Chalice's subsidiary Greenpoint Nevada, Inc. On May 23rd, 2023, Chalice obtained protection under the Canadian Companies Arrangement Act and has been selling its assets to satisfy its creditors. While this TOI applies only to Chalice's Nevada licenses, APCO will also be purchasing additional Chalice cannabis licenses in Oregon. An area of concern was developed during this investigation because during its Canadian bankruptcy, Chalice ceased to notify the CCP of any changes to officers and board members. I am available for any questions, and my understanding is that Russ Rotundi, William Simpson, Gary Zipfel, and Randy Kaiser are available to address any questions you may have as well. With that, Chair Guzman-Freilich, I'll turn the item back.
Thank you, Chief Staley. Could you please state your name for the record? I only see one individual there.
Hello, my name is Gary Zipfel. I'm the Chief Operating Officer of APCO LLC.
Welcome.
We also have Russ and William and Randy on the internet.
Okay.
Good morning, Chair Guzman-Freilich. Can you hear me okay?
I can. Thank you.
And good morning to the board. I'm counsel for APCO LLC, Russell Rotundi with Craft Legal here in Portland, Oregon. And I'm present and available to answer any questions you may have. I'm currently standing in as the point of contact for Greenpoint, Nevada to facilitate this transfer. And again, counsel for APCO. And I would like to just thank Investigator Jeff Justice for his work on this file.
Thank you very much. I know we do have some questions with regard to some unapproved transfers of interest.
So, Chair, I'll just say that APCO LLC was not part, is separate, of course, from Greenpoint, Nevada. Greenpoint, Nevada went through a receivership process. It's an Ontario-based parent company, Chalice Brands Limited. And so APCO, of course, can't speak to the unapproved transfers of interest. It wasn't, they've stepped in here to purchase the licenses, and there's an asset purchase agreement to accomplish that. And so, unfortunately, we're not really able to speak specifically to the what transpired within Greenpoint, Nevada.
Chair Guzman Freilich, David Staley for the record. The area of concern was for Greenpoint and its parent Chalice Brands, not APCO. We were not aware of a unapproved TOI that may have occurred. The concern was that the Chalice ceased notifying us of changes to officers and directors, and we had no way of verifying who was in a position of control as well as what kind of ownership they may hold. But the area of concern goes to Chalice Brands, not APCO.
Okay. Do we have any concerns with regard to the individuals that have any control at the time, or are we solid on that?
David Staley for the record. We have no concerns with APCO or its executives.
Okay, thank you for that. Do we have any questions from the board members?
Member Drat, for the record, I'm just wondering do you have anybody locally that's going to be running this, and who's going to be in charge of compliance locally?
Compliance. So our plan is to transfer the licenses. We have a storage shed full of equipment to start processing with. As soon as this domino is fallen, then we'll begin hiring. We believe it'll be between 5 and 10 employees. There certainly will be someone on the ground who is in charge of compliance and understands the rule set. But we have not started that process because we're working on this currently.
Okay, thanks.
Any additional questions from board members? Any additional comments from the applicants? Okay.
I have nothing further.
Thank you very much. And with that, I'll take a motion.
Member Douglas, for the record, motion for transfer, approval of transfer ownership.
Is there a second?
Member Drat, I second.
Okay, we have a first and a second. Any discussion on the motion?
Madam Chair, Member Douglas, for the record, as to this, I have no problem with the new company coming in, and as I made the motion for approval, as of the parties who were previously in control, I do have a problem with their lack of communication to our board and to the agency chief responsible for enforcement. I would like to see some action taken as to the work cards of the folks who fail to keep in contact. This sets a very bad precedent. They just walk away and we take no action. So I would ask that staff take a look at that. And it would be to the officers previously in charge with, I guess it was Chalice. That would be my request.
Thank you for that. Any additional discussion on the motion? All those in favor say aye. Aye.
Aye.
Aye.
Any opposed? Thank you for your
Very
presentation
much.
today. Thank you. And thank you, council on the phone. Okay, with that, we'll go ahead and go on to item D. This is MedMen Enterprises, Inc. Chief Staley.
Chair Guzman Freilich, members of the board, for the record, I'm David Staley. Item D is a TOI application by MedMen Enterprises LLC. TOI number 2400004 was filed requesting approval for MedMen to sell 2 of its dispensary licenses to Evan Shahara and his company, Mint Nevada LLC. Mint Nevada belongs to a family of independent companies owned or majority controlled by Shahara and are licensed in Arizona, Missouri, Massachusetts, Michigan, and Illinois. Mint Arizona's operation includes a cannabis-infused restaurant. This proposed purchase will mark Shahara's first-time entrance into the Nevada market. On April 24th, 2024, MedMen filed for Canadian bankruptcy protection, and its California operations entered into receivership on April 23rd, 2024. MedMen has been selling its assets to satisfy its creditors. An area of interest was developed during this investigation. Nevada licensees Mesa Oils LLC and Redwood Warehouse LLC are significant MedMen creditors and have requested that the 8th Judicial Court for Clark County approve attachments to MedMen's Nevada licenses or to the proceeds from their sale. Mesa Oils and Redwood have also requested that the court enjoin MedMen from transferring its licenses, but did not enjoin the board from approving a proposed transfer. I am not aware that the court has acted on these requests, and council is advised that the board may proceed with its consideration of these TOIs because there was no court action that may prohibit board approval. I am available for any questions, and my understanding is that Alicia Ashcraft, Amanda Connor, Evan Shahara, and Raul Molina are available to address any questions you may have as well. With that, Chair Guzman Freilich, I'll turn this item back to you.
Great, thank you. Thank you very much. If I could please have you introduce yourselves for the record, and if I could have someone from your group just kind of educate us as far as, I know there's a lot of moving pieces with regard to this item, and we also have some public comment. So if you could just kind of explain it to us in simple terms as to what has occurred and what is pending and what is proposed to occur.
Absolutely. Thank you so much,
Thank
Chair
you.
Guzman Freilich. Alicia Ashcraft of the law firm of Ashcraft and Barr on behalf of the buyer, Mint Cannabis Companies. Ivan Shahara is with me this morning. Also here at the table is Richard Ormond, Chief Restructuring Officer for the MedMen companies in the state of Nevada. Just to simplify things a little bit, a development in the last 5-ish minutes is that Mr. Ormond was able to resolve the concerns with respect to Ms. Primsritz's client that she mentioned during public comment. Those are resolved, is my understanding, and she has left and is not here to make further comment on this item.
She has left the building, and see how much progress gets done when you all come to a CCB meeting. So wonderful. I'm glad to hear that. Enlighten us.
So hopefully that, again, simplifies some of the complications and issues. With the chair's permission and for the board members, I'd like just to take a moment. Mr. Shahara, as I mentioned, is here. Mr. Molina, also one of the officers of the company, is here as well. They do have a brief affirmative presentation, not long at all, just a couple of minutes, that I'd like to turn it over to Mr. Shahara to tell you a little bit about Mint.
Great, thank you. And I do enjoy these, by the way.
Good morning, board. Thank you for your time today and the opportunity to be here, and excited to be in Nevada.
Welcome.
By way of background, Mint started back in 2016. We applied for a couple licenses, won some licenses, rolled up our sleeves, and got to work. Today, fast forward to today, we have 18 operating dispensaries in several states. Part of our ethos is making sure we have a great working relationship with regulators, And by doing so, almost 2 years of working with regulators, we're able to put our innovation to reality. We're able to have the first and to date, I believe, the only cannabis kitchen where you can walk in, order pizza, wings, tacos, all through the dispensary. And that helped kind of build our brand identity. And more importantly, it also helped patients that need an alternative to very sugary gummies. It gave them something else that they could actually take for a more medical need. We also we pride ourselves on being good corporate citizens. We like to work with local organizations and try to find organizations that actually need some help, whether that's through voluntary work, monetary. We support both local fire officers, and even, if there's a need to help plant some trees in a playground that is in need. With that, again, excited to be here, and we hope that we will be a good corporate citizen by employing locally and doing a good compliant job.
Great, thank you.
Thank you.
And then just the last thing I'd like to say is just a quick, very grateful thank you to Rachel Branner, who is the investigator on this item. Immense patience and thorough job, and always a pleasure to work with Rachel. She was a trooper on this one. It's been a long time coming, as the board is aware. It's distressed assets, but we put it together. It's looking forward to bringing the operations back up, and we're happy to answer any questions board members may have.
Thank you. Before I open it up to the rest of the board members, I just wanted to ask, the Cannabis Kitchen, that's in Arizona, correct? Or is that something that is in the works for Nevada? I guess that's my second question.
That is in Arizona. I'd be happy to have the conversation about having it here. That is something that we do locally in Arizona.
And is that something that you're looking to bring to Nevada?
There's a lot of complexities in making sure that it's compliant. So we would have to work closely to ensuring that it is compliant, and we can work the mechanism to make sure that it is.
Fair enough. Thank you so much. Any additional questions?
Member Durrett, for the record, what other states do you operate in?
So Arizona, Michigan, Illinois, Missouri, and hopefully here. And then we're in the process of taking over assets in Florida.
So good start getting local counsel. I commend you for that. Who do you think will be operating locally? Like, will you have a regional manager or?
Yes, yeah, of course. So we're going to hire locally. And we're also going to bring some of the team members here to help with operations until it gets off the ground. And we'll definitely have a local compliance person as well.
I think we saw in the past that was the issue with MedMen. They really didn't have much of a local presence, so don't take their playbook.
No, sure. So, and we're only 45-minute flight away, right? So we take pride in everything that we do.
Yeah. I think that was it. Thank you.
Thank you.
So you live in Arizona?
Any additional questions? And so question for council. So everything has been squared away as far as the motion on the judgment. I know you have a hearing coming up, but it sounds like you might have a settlement. And so from our council, we're good to go as far as voting for the approval.
Yes, Chair. I mean, I think you were before. There's nothing to enjoin you from deciding.
Okay.
Member Mazarin, I have a question. So does that mean that the creditor is going to get paid?
The answer is the creditor is going to get paid, yes, through the close of the transaction.
Thank you.
Great. Well, that is a relief. mean, just because, you know, our job is to protect the state. So the last thing we would want is for somebody to come after the state for approving something where there are creditors out there that have a stake in this. And so that, for me, that makes me warm and fuzzy. So I'm so happy that this occurred, and I'm happy to entertain a motion.
Member Douglas, and before I make my motion, I would ask staff to take a look at the interplay in this particular case in complexity of the bankruptcy and the California receiver. And they had some statements about they weren't really a receiver as of this property, but and give us some clearance and direction in the future as to that. But this transaction, everything seems to go forward. But again, the technicalities and the legalness in terms of boundaries and basics. If you're a receiver in California or a receiver in California, you're not here. They give an explanation. They weren't really a receiver for this property because it was a Nevada property and not a California property.
Yeah, and that's probably not the right description either. So,
Yeah, but
yeah.
It's a cute little ripple to take a look at. But with that, I would move for approval of this transfer of interest to Mint Nevada LLC and wish them good luck. That's my motion.
Is there a second?
Member Mazarano seconds that.
Any discussion on the motion? Hearing none, all those in favor say aye. Aye.
Aye.
Any opposed? Motion carries. Congratulations and good luck. Thank you. Welcome to Nevada.
Thank you, everyone. Thank you. Thank you. We're much appreciated. Thanks for
Thank
all
you.
the years of putting up with MedNet.
Okay. All right. And with that, we are on item 6. This is the consideration of license agreements. And so we've got a 6th amendment to lease between Integral Associates LLC and Fun City Retail Building doing business as Chautauqua Development. And do we have an affirmative presentation on this?
Would you like me to read the item into the record, Chair?
Oh, yes. Chief Staley, please.
Chair Guzman, Fred, members of the board, for the record. Item A is a 6th amended lease agreement between Green Thumb Industries Inc. subsidiary Integral Associates LLC and Cheetac Development. This lease agreement provides for Cheetac to expand the footprint of the space leased to Green Thumb and contains a profit sharing component which is triggered by Integral reaching certain sales targets. CCB staff have reviewed the agreement and found the relationship between the parties appropriate. I am available for any questions, and my understanding is that Alicia Ashcraft is present today to address any questions you may have as well. With that, Chair Guzman, I'll turn this item back.
Thank you, Ms. Ashcraft. What do we have here? Just expansion of space?
Yes, thank you, Chair Guzman, Freilich, Alicia Ashcraft, the law firm of Ashcraft and Barr, on behalf of Green Thumb Industries and its subsidiary Integral Associates. Chief Staley summarized it very succinctly. I would just point out that this is an amendment to the lease agreement. The prior version did have a percentage rent component to it, which was approved in, I believe, October of 2022. So this is just an amendment and an approval of those changes for the board to see again and for transparency. But happy to answer any questions.
Great, thank you. Any questions?
Member Douglas, for the record, concerned initially whether we were kind of crossing the line as the percentage rent. We need to look at the landlord more seriously. In the past, we've done some checks, and this is just seems to be an expansion of the building and more money being put in by the landlord to upgrade his building and so on. And seems to be appropriate, but at some point we have a line of investment and the commingling, and it seems like we're getting awful close. Any comment?
Well, you know me, I always like to walk the line. Understood. I think that those concerns perhaps are mitigated by the fact that these types of agreements are being brought forward, giving Chief Staley and his investigations team an opportunity to look at the landlord, whether you see them more as an investor. But the important point is that you know who the players are and that they're suitable to participate in ultimately what are revenues, to your point, Justice Douglas.
It's noted this is like the sixth or something.
Amendment, yes. Yes, sir.
Oh, I wasn't sure. Member Douglas, are you done with your questioning?
It was just very, very minor.
Okay. Any additional questions? Okay, I don't have any additional questions. Any additional comments, Ms. Ashcraft?
No, thank you so much, Chair Guzman-Freilich.
Okay. Then I'll take a motion.
Member Douglas motion for approval of the license agreement.
Is there a second?
Member Drat, I second.
Is a first and a second. Any discussion on the motion? Hearing none, all those in favor say aye. Aye.
Aye.
Any opposed? Motion carries. Thank you very much.
Thank you so much.
And with that, we'll go ahead and go on to item 7. This is a petition filed pursuant to NRS 233B.100 and NCCR 4.145. And do we have counsel, who's doing the presentation on this before we
Chair,
turn it
I will
over?
be. Thank you,
Mr.
Chair.
Rath. Thank you.
Senior Deputy Attorney General L. Christopher Rath for the record, and I will provide some introductory comments and backgrounds and some key concerns from CCB staff. So this petition is brought by Green Thumb Industries, or GTI, through Mr. Adler. They submitted a petition to the CCB seeking to amend NCCRs 1, 6, and 11 to first change the definitions of lot and production run, change the process for quality assurance testing of cannabis, and change the testing requirements for aspergillus. The petition provides proposed changes to NCCRs 1.125, 1.165, 6.100, and 11.050 subsection 2. The petition does not seek wholesale adoption of the proposed changes. Rather, it seeks another workshop on the issues that it presents before any changes to the NCCR are finalized. The petition is virtually word for word the same as a petition Mr. Adler filed in 2022 with respect to the definition changes in the quality assurance testing. There is a new item that is requested to eliminate all testing for aspergillus. The board denied the prior 2022 petition without prejudice. As some of the board members may recall, the 2022 petition garnered some significant opposition from cannabis labs and others. Some board members had wanted to see the factions within industry try to come together to work out some sort of compromise before coming back to the board with the same or similar petition. It appears there has been some movement in that regard by the Nevada Cannabis Association, or NCA, who it's my understanding is working on a study of lot sizes, which may involve one lab. However, I think NCA is here and they can elaborate further on that. Other than that, to my knowledge, not much more has been done to bring the industry factions together, or they haven't come together other than this. Moreover, the CCB did just recently hold a workshop on new lab regulations in April 2024. At that time, public comment was taken, and the issue of lot sizes as well as aspergillus testing was addressed. No changes were made to the regulations on those issues, and the CCB subsequently approved the new lab regulations, which were submitted to the LCB. At this point, the CCB staff continues to have concerns over the proposed changes. They are largely the same as those expressed at the hearing of the 2022 petition and at the April 2024 workshops. Briefly, some of the staff's key concerns include the following. As to the proposed changes to NCCR 1.125, such a large increase in lot size, up to 5 times for flower, will increase the risk of inaccurate test results due to a greater chance that microbials such as salmonella would be missed. Labs would need to collect a greater sample size, which is not provided for in the proposed changes. If a sample fails testing, then an entire lot may have to be destroyed, which would result in the destruction of much more cannabis. As a result, there would not likely be a cost savings for the cultivators and producers. Additionally, there were no studies or data to support the requested changes with the petition. Studies do exist from both 2013 and 2023 that support the continuation of the CCB's current lot sizes. As to the proposed change to NCCR 6.110, this seeks to test only final cannabis products and would eliminate any testing for usable cannabis and intermediate cannabis products, which could be an issue as then we don't have all the information as to what might be contaminated. Also, not all failed use cannabis may be appropriate for extraction. And lastly, the request to eliminate aspergillus testing is potentially problematic. The April 2024 workshop reviewed that issue in great detail. As the staff emphasized then, CCB is only testing for 4 specific species of aspergillus, which is known to cause illness and is frequently found on cannabis. Kara Cronkite might have some additional comments on these issues and is available to answer any questions, and I believe we will have public comment for a number of others. I'll turn it back to you, Chair.
Thank you very much, Mr. Rath. Okay, with that, welcome, Mr. Adler and company. If you would just state your name for the record and let us know what it is that you're doing, what your petition is all about, and how this is different than the prior petition that was denied and the workshops that have been held and regulation changes. With that, welcome, Mr. Adler.
Thank you. Will Adler for the record.
Tiffany Newburn Johnson for the record.
And hello, Chairwoman Guzman Freilich, actually, and board members of the CCB. My name is Will Adler, and I am the principal of Silver State Government Relations. I want to first thank you all for hearing this petition today. Honestly, I know this petition is controversial. It is controversial by design. It is my greatest hope that the members of the board will ask all questions that come to them as they arise through the presentation of this petition and the comments from GTI and their experts. It is that this very discussion and that debate is why we brought the petition back before you today. Lab testing is an issue that has been long debated in the cannabis industry, but it's been debated amongst the industry. This is a debate that cannot be solved by the industry either. As you've seen and heard and somewhat correctly heard from staff today, I and GTI have personally commented on this issue for 5 years running, actually. I submitted a petition back in 2022, which actually was not heard. It was rejected on the merit that it was identified from the Sierra Cannabis Coalition. And we were thrown outright because we were incorrectly submitted, not from the content of the petition. In fact, the board and staff did not read or hear the petition that day, but we were told there would be a workshop and there would be a further discussion on lab testing from that petition, February or March 2023. That petition discussion never arose after that. Since then, we did actually comment on all the workshops in the 2024 session, but no part of the workshops actually allowed for the open debate and discussion of lot sizes or anything we brought in this petition today. One public comment section was opened up at the beginning of one workshop where thankfully Mike Miles and I did have an open discussion about lot sizes, but it was never actually included in any of the workshop material, just to be clear. With that, I would like to say that I hope the history of Nevada's lab testing can be brought forward, the relevance of the long-term reliance on the 5-pound lot size, and that we can actually talk about what could be done to progress this going forward. With that, though, I would like to open the floor to Ms. Tiffany Newborn Johnson and GTI and their team. Thank you.
Thank you. And hello, Chair Guzman, Freilich, and members of the Cannabis Compliance Board. Again, my name is Tiffany Newborn Johnson. I'm the Director of Government Affairs for Green Thumb Industries. GTI operates in 15 highly regulated U.S. cannabis markets, giving us a firsthand knowledge and experience with how testing practices impact businesses, product quality, consumer health and safety, and ultimately consumer costs. I'm here today to urge you to approve our petition to modernize and streamline Nevada's cannabis testing protocols and bring the state in line with the majority of its peers in the regulated cannabis market. Specifically, we're requesting an increase to the maximum state lot size above 5 pounds for flower and 15 pounds for trim, allowing testing on any amount of concentrate made in one production process, regardless of the quantity produced in the batch, and streamlining the final product, streamlining testing of the final product, and then finally to review the threshold requirements for aspergillus testing. On lot size in particular, we'll focus on 3 main points. First, there's no direct correlation between lot size and consumer safety. Joining me today via Zoom is our Director of Quality Control, Antoinette Duncan, who will highlight our data on the rates of consumer complaints relative to lot size. Our data shows that there's no clear evidence that a smaller lot size results in fewer product recalls or serious adverse events. Interestingly, the Americans for Safety Access 2022 report, which analyzes and ranks medical cannabis programs, scored Nevada at a 148 out of 200 possible points for consumer protection and product safety. Despite Nevada's small 5-pound lot size, other states with larger lot size scored higher in this area, including Maryland at 169 out of 200 with their max batch size of 20 pounds, and Connecticut at 160 out of 200 with their max batch size of 40 pounds. A recent report issued by the GMP Collective on lot sizes and sampling protocols found that the most effective means for protecting public health is to implement market-relevant accredited standards and best practices such as quality management systems and good manufacturing practices, rather than restricting batch size. Point number 2, Nevada is in the minority of U.S. regulated cannabis states with having such a small lot size of 5 pounds, which was established nearly a decade ago. According to the GMP report, of 38 states with legalized cannabis marketplaces, an overwhelming 92% permit lot sizes exceeding 5 pounds, with 26 states allowing for 20 pounds or more, and of those, 13 states impose no maximum limitations at all. Washington and Maryland recently increased their lot sizes. Washington increased to a maximum of 50 pounds and Maryland to a maximum of 20 pounds. Point number 3, restrictive lot size policies result in higher cost to the business and ultimately the consumer, making the illicit market more attractive to price-sensitive consumers. A single test to evaluate the quality and safety of cannabis can cost between $400 to $1,000 and upwards of that, which often results in increased final product cost. Larger lot sizes improve operational efficiency, which allows for cost savings and better resource allocation towards maintaining safety and quality. And finally, in summary, approving this petition, particularly increasing the lot sizes and focusing on accredited standards and best practices, will bring Nevada in line with industry standards, improve operational efficiencies, and help reduce costs for businesses and consumers without compromising consumer safety. GTI stands ready to work with the CCB, industry stakeholders, and laboratories to improve the Nevada testing practices. At GTI, consumer safety remains our top priority in all policy reforms. So thank you for your time. I'm going to hand it back over to Will to go through the petition.
Thank you.
Thank you all. You've all received the petition and have had plenty of time to review it, so I will just go to the sections of the regulations that we addressed to show why we addressed those and what we were thinking by targeting those. Regulation 1, we went right at it with the definition of a lot size. This is a weird one in general because I was in the room when it was actually identified. It was the ILAC meetings back when we were under the Department of Health. And the actual discussion was how much will be stored at a single time. And at that that time, we had toured 2 whole cultivations in Colorado, and they stored them in Home Depot buckets. And 5 pounds of material fit in a Home Depot 5-gallon bucket. And that was about the logic we used at the time. I'm not exaggerating at all. And the letters we've submitted from the former director, Glenn Miller of ILAC, said much the same. Nevada picked a standard because we had to at the time. There was no other states that actually had regulated lab testing standards anywhere in the country to refer to. We had to have something on the books to begin growing, so we knew what we would be testing for when cultivations had their first harvest ready. It was that need and that time crunch that generated a reasonable standard at the time of 5-pound lots. But as we've seen, every state since then, and every state that had a 5-pound lot prior, has addressed it in some way where Nevada has not. Today and now, GTI's petition is saying we can move the 5-pound lot to a 25-pound lot, looking at what Nevada has in its structural economy. We are not an outdoor growing state. We do not have outdoor cultivations. In that sense, I do not think it would be appropriate to have an unlimited or a 50-pound lot size. It makes no reference sense to the actual businesses operating to the poundage that we would request. We did that because indoor cultivations at best would have a massive harvest, would be a 25-pound lot. I don't think that's going to happen in a lot of senses. And I don't think a lot of operators actually choose to do that because, as I've said, Nevada's cultivations have structured themselves around growing for the test today. But today and now, those operations end up with 7-pound harvests, 11, 16-pound harvests, because plants are plants. They grow in organic matter, and there is no fixed 5 pounds that comes out of a certain number of plants. So just for operational integrity, we are looking for some flexibility from the board because we want the same standard. We want the same test. We want the same assurity to the customer, but we also want efficiencies that should be a reality for operations. So having those reference points, 25 pounds seems also appropriate for trim because we do have 15 pounds today, and leaving that at 15 pounds would seem kind of silly. So generally, we want to have this discussion with the board because this is not something we can progress as an individual company. This is a discussion that is for all operations across Nevada. And as such, it is something that one company cannot bring forward, but the board could address through a new workshop, through a study, or through a survey and poll system, because you have access to every license holder in the state. I cannot tell you what people tell me is the right operational size for their business, but you do have the means to access each license holder through a poll or a workshop to ask what is the right number out there. So that's why I identified 25. We think that is a realistic number for Nevada. Production run and its definition as well. Back in the same situation, we had to come up with the number, so we used 1 kilogram. But as you see operationally, some operations don't actually draw 1 full kilogram in a single production run. They have smaller rigs. Some draw more than a single kilogram because they have multi-stack operations that, for efficiency's sake, juice a lot of cannabis at once. And that's how you end up with a production product that is sometimes larger than 1 kilogram. Regardless of size, the scientific efficiency and the correct stance, I think, is if there's a single production run at a single time, the batch result of what comes out of that should be tested as one test because it is a single unit. It is what came out of that production run. Going through to 6, section 6, we identified the single step between quality assurance and production is this transfer of products. So prior to transfer of any cannabis product, it must be tested. This was a mechanism in place visualizing, I would say, a less vertically integrated industry that ended up in Nevada. Today and now, maybe the majority of pre-production tests are done by people who have their cultivation across the wall from their production facility. There's usually a lot of knowledge of what is in that cultivation trim because they usually already got it tested for the flower. But today and now we have a mandate of this secondary test prior to production when you ultimately test the end production product and you know what's in it. Yes, there is some assurity factor where if I'm a cultivator selling my trim to a third-party production person, there might be some lack of knowledge. Hey, I better not sell them dirty trim. But if there's an operator in the state of Nevada today that still has that question, I think that understanding is between the production company and the cultivator. If they want to mandate a test prior to purchase, that is their right. But I do think that is another business decision or operational flow that ultimately doesn't do anything to validate the end test of a production product. When it comes to aspergillus, I won't go through every section there, but we identified aspergillus previously and had good discussions on it, where aspergillus is not an identifier of maybe a bad lot. Aspergillus is a zero-sum factor of identified or not. When you identify aspergillus, though, I have always advocated to my cultivators, do a retest. And I will swear to you that there is a 100% retest pass, or at least a 95% plus retest pass on the retest of aspergillus, because it is such a undetectable variable. It shows up or it doesn't because it is apparent in live plant matter. So to address this, we did say aspergillus is a non-testable test. If you can retest it and over 90% of the time you get a pass, it is a luck factor whether you hit aspergillus or not. And the additional cost, though, for aspergillus should be known. Each time you have to plate a lab testing for just aspergillus, it alone has its own kit. It is a disposable kit that is a one-time use, and it is a fixed cost to each lab test we have today. The fixed cost compared to the actual identifiable benefit, I think is something that we should at least look at, if not try and do a ratio of value on, because there is a cost to each lab that has to buy that kit to do each test, and that is ultimately passed through. But that test has some validity questions if you can retest it and have a continual pass rate. But I don't know the metadata. I would love to actually have this discussion with the CCB, because I only know certain cultivations datas, but I think it would be of great value to have this discussion brought to a greater statewide level, because that's something I believe, but I need you guys to help, validate. In addition, I would just like to say these factors are not us complaining about Nevada. This is taking a meta view from GTI's multi-state operations, looking at how those operations function and how those operations have successfully had continual success with no major impacts to consumer safety for sure, but consumer satisfaction as well. 5 pounds does not make better marijuana, but it is where we are today in Nevada. But I would like to turn it over to Antoinette, if she's able to. Yep. To add some more discussion about the multi-state operations and what we see in other jurisdictions.
Good morning, Chair and members of the Cannabis Control Board. I know Tiffany introduced me, but my name is Antoinette Duncan, and I am the Director of Quality for Green Thumb Industries. I've worked for GTI specifically for 1 year, but I've been in a quality assurance professional for almost 20 and have worked in cannabis specifically for the last 7. I am also subcommittee chair for ASTM D37's technical committee for cannabis. Part of my current responsibility at GTI is to monitor consumer complaints and quality trends across several markets, all the markets that we operate in, all having a larger batch size and lot size than Nevada. I have personally seen no correlation between lot size and the instances of customer complaints with serious adverse events or risks to consumer health and safety. And I'm going to summarize some of the data at this time. There have only been 6 serious adverse events reported for flower products in the past 2 years across 4 different markets that GTI operates in. That is Rhode Island, Florida, Minnesota, and Ohio. Ohio has 3 of the 6 and they have one of the smaller batch size limits in the states that we operate. Serious adverse events did not trend proportionally to the batch size across the states. No serious adverse events were reported in the states with the largest allowable defined batch sizes, which are New Jersey, Pennsylvania, Illinois, and Maryland. We also track complaints related to customer satisfaction. This includes things like poor taste, bad smell, seeds, underfills, etc. These do not trend with increased batch sizes as well. There are 5 states currently with unlimited batch sizes, and the complaint rates across those 5 markets was anywhere between 0.07 per 10,000 units sold and 1.5 per 10,000 units sold. Nevada complaint rate falls right within that range at 0.3 per 10,000 sold. Essentially, this means that there was less than one complaint per 10,000 sold in all but 3 states, and there was still less than 2 per 10,000 sold in the remaining 3 states. So we have a very, very low complaint rate regardless of the batch size, the maximum batch size in those states. Illinois and Maryland specifically both have maximum batch sizes of 20 pounds, but Illinois has a complaint rate of 5 per 100,000 sold, and Maryland has a complaint rate of 1 per 100,000 sold. Nevada actually falls right in the middle of that at 3 per 100,000 sold, despite having a max batch size of 5 pounds. This further demonstrates that batch size does not have any impact on the complaint rate. Overall, complaints for flower are extremely low. Average across the network for GTI is 5 complaints per 100,000 sold. Since I started a year ago, there has been 1 single recall for the potential consumer safety issue, and it was in the state of Illinois. Illinois has a max batch size of 20 pounds. We have not had any flower product recalls in any of the states that have higher or lower batch size limits. So those are my points, and I'm happy to take any questions.
Thank you. Any additional presentations or comments by the petitioners?
I would say this is the close of our petition presentation, but we would like to stay present for additional comments or questions from the board. At this time, we hope that it is clear that, you know, this petition is, I said, controversial for a reason, because it was meant to be. It is to get the conversation started and hopefully, you know, show that this is a continual issue in the state of Nevada. GTI is trying to do its part to identify this from a multi-state operational level and an efficiency level, but this is something that every operation has to face and every person should be aware of, because the ultimate cost of cannabis does matter in Nevada. And if we can do everything we can to lower that cost and lower the efficiency, we will ultimately capture more of the cannabis smoking market in this state. Today now, I've heard time and again that the safety of the consumer is what we must put first and foremost here at the CCB. But I will say not every cannabis consumer are those that are priced into the current legal cannabis market. We've had many, many stories, and one in Carson City itself, that we are hearing of consumers going to the streets, buying, you know, hemp that can get you high online, right? And other spiced ingredients that are causing real downturns. But one gentleman in Carson City actually purchased what he thought was cannabis from somebody in his apartment complex that was some cannabis sort of substrate that was dosed with fentanyl. That man drove himself to the hospital and had an overdose, but he came into our stores to tell us, I'm never leaving you guys again. Please have more sales because I can't afford your weed as often, but this almost killed me. But this is something that we should really look at and say, who is the cannabis consumer in Nevada and how do we make more of them legal consumers in our stores? So thank you for hearing this today, and hopefully we can get the discussion going on lab testing and, consumer facing efficiencies from the businesses. Thank you.
Thank you. I'll hand this over to the board members for questioning, as well as any questions from staff with regard to the petition. And then we can open it up to public comment before we bring it back to the board for a vote on the petition. Board members, any questions from the petitioners or from staff?
I have a question. Member Durrett, first, it didn't even occur to me until this morning, this petition process was created in 2019 when the CCB was created, when the regulations were taken out of the APA. So this was a way for regulations to be adopted. And at that time, it was anticipated that it wouldn't be going through the APA and the legislature. So now it's kind of.
It has to go through the legislature. I mean, we'll go through LCB first. And
so, all right.
And, obviously there's issues with timing as to when you can do that.
Yeah. Okay.
In the upcoming legislative session.
A couple more questions. The test for aspergillus, the test is for any aspergillus, right? And then if it is positive, then you test the four to see if there's the four harmful strains?
No.
Or is it just for those four strains?
No, we only test for those 4 strains specifically out of over 200 different strains of aspergillus.
Okay.
Those are the 4 pathogenic that are known to cause harm from cannabis.
Okay. I have a question that I think is better for one of the lab representatives, but then I would think GTI would want to respond. So maybe I'll ask you guys first, but then ask the labs. In the BOTEC report, well, I think I have to ask the labs because I want them to walk me through how the specific language that supports the 5 pounds. So I'll ask them. Those are my only questions. Thank you.
And maybe the BOTEC report is a good thing to bring up or to talk about, because that's exactly the position I want to talk about, is the gulf between cannabis cultivators, producers, and dispensaries and lab testers is vast and clear, because it should be, right? They're the watchdogs of the industry. They're this third-party monitor, but we can never bridge that gap between ourselves, and our science will never match their science. Our science will never be superior to lab testing science either. So the idea of us or the industry itself or the NCA holding a study independent of lab testers to show what science is better than what, I think is a fool's errand. I do think we need the board to be a mediator, be in between, and have this interplay between the industry, because they are our watchdog and they have their own opinions. They should. But we do have evidence and structural difficulties in Nevada that aren't in other states that we think could be bridged in some way. And there is a middle ground there. But I do think the BOTEC report shows people have strong sciences, and the board really could be the mediator there, because no evidence we produce would actually trump a BOTEC or whatever the next round would be. Yeah.
Okay, that's all my questions.
And I wanted to piggyback on that really quickly. And that question's for you, Mr. Adler. Why now, considering that we are our hands a little bit tied with regard to regulation? So even if we were to hold workshops for a regulation change, those changes would not happen until after the 2025 legislative session. So why, I'm just curious, why bring the petition now versus after the session?
If it takes $500 to be in front of you fine people, it's the best $500 of my life. But that is truly, in summary, the reasoning why, because we did participate in every function that we could. Every workshop, every prior workshop, every comment period for what should be workshopped. We mentioned each and every one of these issues. We asked for a place in the workshop process, and were rejected outright throughout the 2024 cycle. But in addition, we did do a petition prior to your inclusion to the board in November 2022, and nothing had progressed from that petition prior. But why now? The real answer is now is literally better than never, but also now is a perfect time to start, because I don't think this will be a slow process or a quick process. I don't think this will change over, or that these regulations could change just from my petition. But I do think if the board took this on in a thoughtful process focused way, it would take some time, right? And it would take a collective study, or it would take a series of Q&A sessions with the whole industry, doing informational sessions or asking for survey response requests to get to that balance of what is the right answer. Truly, I think you could do that, but we felt left out of the current workshop process. We know that it is too late to be included in this year's cycle, and that we're going to have to go to the 2025 legislature and wait for that to happen in addition. But prior to regulations being adopted, I think lots of industry participation and research can be done by the CCB as an entity to bridge that gulf, like I said, between labs and the rest of the industry to get this started. Because I think the attention this brings is of value itself. to show that this issue is continual and has yet to be addressed and isn't going anywhere. Thank you.
I have a quick question for staff. When the petition came before the board in November of 2022, and it was dismissed without prejudice, was that because it wasn't in proper form, or did it actually get a hearing, or was it just dismissed because it wasn't in proper form?
Kind of both. It really was not from an interested party, which it had to be, and it was discussed at some length, substance-wise, and it was, you can see the comments from the earlier minutes that I think some of the board members wanted industry to try to get together and figure things out before it came back again. So that's sort of the context.
Okay, thank you.
Member Douglas, for the record, also, it was dismissed without prejudice to allow them to come back. If we had dismissed it with prejudice, they could not come back in a reasonable time. So this left it open to see, as pointed out, what changes were going on in the industry across the country. And as you know, and the problem with some of the information we're receiving, Maryland for one and some others, with public sales, open sales, Maryland is year in. They had some med before that. And that's the problem looking across the board. What they have going on in their state. Was it retail? Was it medical only? What type of limitation? Do you have a state lab versus independent labs? I know visiting Florida and seeing one of their facilities, they had labs on every one of the facilities before it went to the state lab. They're not that sophisticated, but it's important to keep up with what are the changes. So it's worthwhile. I am concerned, though, with the ability of our legislature to amend things. I know the procedure we're now in, we're very limited, but the legislature is not as limited as we are with doing things. So I think it's important to get information on the record so it's there for both sides.
Chair, can I make another comment along those lines? I completely agree that it's good that the petition was brought to keep the issue going, and we do need, testing needs to continuously evolve. We had that ILAC committee that would have been continuing to develop testing regulations, and this is going to continue to move towards GMP throughout the United States. So we really need to be on top of those trends throughout the United States. So I'm glad that you brought it, and I do hope that we can continue to hash this out and make some progress on it. And I appreciate that GTI is very involved in Nevada, because I had made those comments earlier about a company that was not so involved in Nevada, but GTI has always been very involved in Nevada, and I appreciate that Tiffany is so available when she has a perspective across the United States on what's going on. So thank you. Thank you.
Any additional comments or questions from board members for staff or petitioners? Okay, I have a question for Mr. Rath. So what would the process be? We're going to hear public comment, but what would the process be with regard to this petition? If the petition is granted, then it goes to public workshops and events?
You'd have to initiate the regulation process, which would include a workshop, and then working up a regulation and submitting that to LCB. However, the issue is any new regulation is not going to be put in place until after the legislative session, unless it's an emergency regulation or a temporary regulation, which would expire in November. So there's kind of little point in doing that before next July.
Okay, and if the petition was, yes, and it would be, I mean, probably a long time after the session ends, because then they're busy writing the legislation, right? The that
And who knows
passed.
what the legislature's going to do in the interim either, so.
Right, okay. And then if the petition was to be denied, then then what would happen? We would have to have reasoning behind it, and then a decision is written? Is that the process?
There would be a written order. You could deny it with prejudice or deny it without prejudice so that it could be,
brought back
again at the appropriate time. So that's an option. But even if it's denied without prejudice, there has to be some reason stated.
Okay. Any additional questions from board members, of staff, and of the petitioners before we open it up to public comment?
I have a question, Member Drett, for the record. Would there be a downside to granting it for the purpose of holding a workshop for the legislative session? Or would that put us in the situation that we've now opened up a regulation process and we have to meet these deadlines that we can't meet during the legislative session?
It would.
I think it would. I'm not really prepared. Joseph Ostunio, for the record. I wasn't really prepared to speak on this. This is kind of outside of my purview right now, but I could get back to you and I could get you some dates. I would recommend tabling it, maybe. That's always an option. Or deny, yeah.
Yeah, I mean, if you're going to table it, I think you essentially have to deny it without prejudice. That would be the same. I don't think tabling is an option, but I think you can deny without prejudice would be the appropriate way to go according to 233B.
But then would they have to file it again, possibly wait to get back on the agenda, pay again?
Well, we have to put it on the agenda within a certain period of time, so.
Under 230,
Is it
I'm sorry.
possible to continue this matter to our next meeting to get an appropriate review of?
Under 233B, you've got to either deny or grant the petition within 30 days.
Wait, I'm sorry, but this petition process is not under 233B. It's under.
It is.
It
It's
is.
under.
It is. Our regulation is from before 233B, but it's actually under 233B.100. So you've got to deny or grant it within 30 days. And if you grant it, you have to proceed with the rulemaking process. However, if you, for instance, wanted to table it or continue it, the best thing to do would be to deny it without prejudice, with the reason being it's premature or there's not enough data.
And if I could point out something really quickly, if they're concerned about the fee at all, I've been working with LCB on changing the regulations to the NAC. The $500 fee is going to get taken out, so there won't be a fee.
Worth it. Record will happen.
So can I just ask council, with regard to if it's granted, if the petition is granted and you have to, do you have to start the regulation process, meaning you have to have a workshop within certain amount of time, correct?
I don't know if there's a deadline on the workshop, but you do have to start the rulemaking process, which would include setting a workshop and going through the whole process with LCB. And again, the best you're going to do before a legislative session is going to be an emergency or temporary regulation, which doesn't seem appropriate here.
I guess my question is,
No.
could you go through the entire rulemaking process, but then it's just going to sit on their desk until next year? But at least on this end, that's if it was granted. Then on our end, we go through the process as if the legislature wasn't meeting and there wasn't that obstruction of not being able to get the regulations looked at and amended and adopted. We would just be doing the regulation workshop and submitting our information, then they just sit on it until next year. Is that right? Or is it a little bit more complex than that?
I don't know the timeline of LCB. I'll just read from 233B.100. It says, upon submission of petition, the agency shall within 30 days either deny the petition in writing stating its reasons or initiate regulation-making proceedings, which means you have to go through the entire regulation-making proceedings. And again, you can't really do anything until after legislative session unless it's a temporary or emergency regulation, which I don't think either is appropriate here. So, I mean, it's kind of up to you how you want to proceed, but in terms of efficiency, it's probably better to rehear it after legislative session. But that's my opinion.
Chief Cronkite for the record. And if this was denied with prejudice, then without prejudice, then staff could still work with the industry on the issue and work with the NCA on their study and gather the information during the time frame that we're not allowed to change the regulations. And I'll speak on behalf of the CCB staff. We'd be happy to do that.
Okay. Member Mazzarano, I would like to ask, what would be the harm in granting it and moving forwards slowly, knowing that we aren't going to make any real changes, but we at least showing good faith effort into trying to address all these issues?
Jimmy Hum for the record. I guess I could say also we could go through that entire process and then the legislature could render it all moot if they have a different opinion and chose to go in a different direction through legislation.
So that's why it is a little risky, because we don't know what the legislature is going to do. They could take up this issue. They might not take up this issue, and it leaves us in limbo.
Am I allowed to speak in this junction? Will Adler for the record. I literally my intent, or sort of what I would love to see actually, is the beginning of this process, the beginning of the regulatory cycle. But even before that, even before we actually get to a workshop, the staff of the CCB could do a lot to arm themselves, or even the legislature, with good data and new data around industry surveys, understanding about what desires are and sort of where people are at on their own opinions on survey the labs even, right? Survey, literally get some good data points. What is the desire among cultivations? What's the desire among production facilities? Do we still feel a hard and fast need for that pre-test before production? I cannot vouch for the whole industry, but I do think you have the means to get that data in front of you and produce it even before the legislative cycle. Could have a lot of merit and could show where this conversation's at on an industry-wide scale. But I literally can't produce that and validate it as Will Adler. But I think the CCB could take this on in some form, and it would not do harm prior to the legislature if we show that this is of interest and that we're trying to quantify what is the need. You know.
Mr. Adler, what about something in between the CCB and the legislature, which would be the advisory commission, where they would take on this question, and there would be all that discussion that you want to have, and then at the end of the day, they would have a recommendation that they would submit to CCB or even the legislature or both for changes that you're seeking, or maybe for no changes, depending on all the testimony that comes before them. And it wouldn't be in a regulatory, in a regulatory sense. It would be more of a discussion that you're seeking to have a discussion and to come to a consensus with all the parties present.
Yeah, just, if that were to happen, we could continue to do the surveys and stuff that you were talking about to supply the information to them.
Will Adler for the record. I'm not sure of the current state of the Cannabis Advisory Commissions or the subgroupings of them. I know some are more full and some might have some vacancies on them, but I'm not sure exactly which subsection would take this on, but there's a laboratory one, and I know there's a couple other groupings, but I think this is sort of, as long as the CCB is taking the lead and going through one of them as the vessel and agrees with some structure of, let's figure out what people want and get industry surveys and data going. We'd be open to participate in any vessel you guys choose to go through, I believe. I don't want to speak for GTI. over the top, but, you know, a commission or some process, the discussion moving forward is our desire. So, yeah.
Well, not to put you on the spot, Director Hum, but since you are the chair of the advisory commission, is this something that would be something that the commission would take on and either do a subcommittee or just the commission as a whole?
We could certainly take it on as a subcommittee. I think that would probably be the recommendation. My fear is there's shortened time before the legislature. So for all of those, including some of the folks who are constitutional officers or fellow directors, I don't know that we could get a formal recommendation done in time through that CAC process, especially, again, given other commitments. So I would think, again, if we were to, Deputy Director's point, commission those, the workshop and things of that nature, I think that would probably be faster than trying to get all those folks together, subcommittee, then larger committee approval. So again, to Mr. Adler's point, the idea of this was to foster conversation, to bring this issue to the forefront, which we have expressed willingness to do, again, certainly at least under my term, starting back in April when we opened up all the regs. So happy to proceed in any manner that the board would want to. I would think the more the workshop approach would be the fastest. But again, with that caveat that anything that we do all could be undone by the legislature. But happy to have those conversations. I know that's why Mr. Adler's here.
Sure. And the reason, and I'm not trying to argue or anything like that, of course, because you know the CAC better than anybody else. But, you know, under open meeting law, it just takes two people to have a quorum and of a subcommittee. And I was just thinking that perhaps that might be, if you get two people together to hear everybody out, it may be more economical than having CCB workshops that take, you know, staff and, you know, and everybody's, and it's an actual workshop. So we're in it. We're on that track of a regulatory workshop. But I'm just throwing out ideas and, you know, whatever is what this board decides is what'll go forward. I just want to just throw out ideas and hopefully something will stick.
Chair, I will, Jimmy Hum, for the record, I will address that as well. We actually do 5 on the subcommittee, so it's 3. And then we need 8 out, I believe it's 7 out of 12 for the CAC. And honestly, we have the best team in the world here. So we would put in the same amount of time on those workshops as we would any of the CAC subcommittees. So whichever route you select, I can assure you we will dedicate the resources to that. And honestly, they would probably mirror one another because the two wonderful people to my right would conduct those as well, both of those as well, and be here to answer all of those questions, as well as give the public an opportunity to respond, as well as submit comment, as well as appear before both of those bodies, so to speak.
And if I could be blunt on part of it, the regs were just completely opened up in April. We did discuss these issues, both of these issues. True, we didn't have your language in the regs that we presented, but that's because we present the language we're pushing to get approved. We made a bunch of changes on other regs that people brought up. That wasn't one of them, and it was solely because there was no safety study that counteracted the safety studies that we already had for the 5-pound lots. And that is the reason why it wasn't really looked at to be changed at the April workshops.
Mr. Adler, you were at the April workshops and you talked about the changes you're trying to make here in your petition at the workshops?
Yes, so we commented at the pre-workshop comment periods in January and February, I believe, and we asked for inclusion in the workshop process of this discussion point, and we thought that would bring forward the discussion we desired at this day from the lab committees, from the industry, from cultivators and producers, if it made it onto the workshop document. It did not make it onto the workshop document, and we had prior conversations about, you know, wanting to see that conversation heard, but we did have a public comment period prior to the workshop where we spoke to this. But yes, we submitted very detailed comments to reference Washington State, the changes they had made and why. But we are not, or Will Adler himself, I will say for the record, is not a body of safety and scientific data here, because as I said prior, there's no metric for a correct safety study in one state. And to produce that, I would need data that literally the CCB probably is the only container of, because I can't get behind the data wall of every single company and every single lab in the state of Nevada. And there's no way I could actually quantify enough of the data as an individual or as one corporation to produce a statewide study that would hit a bar of excellence or even satisfactory in that setting. So that's why we did not produce a safety study at the time. And we had been told by staff, hey, other states have told us that they wish they had done better safety studies before they made those changes. But that equally is sort of a veil of, okay, so what? I mean, let's have that discussion amongst the industry and say, what do you want to do as an operator and what do you want to do as a lab, and come to that middle? Because I think the operators will come to something that doesn't look like 50 pounds either. I think they'll come to something where they'll look at their current operations and say, streamlining this, heck, we would die to have 15 pounds because our tables come at 11 pounds, 12 pounds consistently. And that's 3 tests today of one single strain grown in a single room at the same time, right? But that discussion never materialized because we didn't get it on the docket, and we couldn't actually generate that industry-wide interest because there was no hope of it actually becoming a regulation. It wasn't on the workshop. Yeah.
Can I just add to just, we've also looked at other like agricultural industries, including like the tobacco industry, and no other agricultural industry actually limits the batch size for testing. Everything is based on harvest. And so that's what we would be asking the CCB to also consider today. With the harvest batch, they do consider other factors like the GMP practices. And those are something that we think the cannabis industry should be held to that very similar standard for agricultural industries based on harvest.
Chief Cronkite, for the record, I just want to chime in on tobacco specifically before anyone gets too carried away with that comment. We have looked at the sampling techniques for tobacco, and because it is all the tobacco leaves, they're more of a homogeneous mixture. They don't have the heterogeneity of the cannabis plant like you would see in the flower buds and things like that. So I do want to caution against using that as a direct reference, but there might be positive points to pull from that.
Harvest part, yeah.
Thank you. Any additional questions from board members before we open it up to public comment?
Member Drett, I just want to say that I do support some route, whatever it is, to get more testimony from all sides on this, and even before the legislative session, because as much as the legislature, the legislature's, the policy body, and they dictate to us what we do, they can use the evidence being developed by us, because they're not going to have all the time in the world to go over it either. And I think this is a much longer conversation than we can have in this capacity.
Thank you
for your time today. Yeah.
Okay, and with that, we'll go ahead and open up public comment first in the south, then the north, then online. Do we need to give instructions for online comment?
No, we do not.
Okay, thank you. Comment in the south, and if you come up to the table, if you could please state your name for the record for our court reporter. Thank you so much.
Fulton on behalf of the law firm of Jennings and Fulton. I'm here today on behalf of the laboratories.
Kimberly Madison Rushton with the law firm Cooper Levinson, appearing on behalf of the Citizens Public Safety Alliance.
The laboratories we submitted, if you had an opportunity to read my letter and the oppositions to it in detail, you'll find that and there's a lot to talk about here today, okay? And I want to be careful that I don't talk for 3 hours, right? Because I know you don't want to hear me drone on for 3 hours. So I think that it's important to remember that the most important thing here in Nevada, and I love Justice Douglas saying, best practices, right? What is the best practices for our state to ensure safety of our citizens. That is more important than GTI making more money, okay? Science and safety should trump money. While money does matter, the safety of our citizens is the most important thing. So a couple comments that I want to address that Mr. Adler made. First off, I'm going to address some of the comments he made, and I'm going to go into some of our points, and I'll address your question, Member Durrett, on the BOTEC paper, okay? So we just went through a whole workshop protocol, and I sat with Director Miles and Director Conkright. There were multiple witnesses and testimony given, which included the 5-pound lot size issue. It was brought up during that testimony. There was live testimony given. You both were there. We laid it all out. I represented all the laboratories at that time, and you heard from multiple lawyers who gave the position of why the 5-pound lot size is important for this state and the safety of our citizens. So to request an additional workshop when we've already done it, and we've already gone through the regulations, we just finished revising the laboratory regulations, and staff was phenomenal in working with us in that. Took our science, we had multiple workshops and meetings to try to explain the science behind why the regulations need to be the way they are. This has already been done and accomplished. So to say that we need more workshops on something that's already been addressed, we already addressed it. It's already done. He states that there's no direct correlation between lot sizes and the public safety, and this is simply not true. When you look at the actual scientific papers, if you look at the BOTEC paper from 2013 and you look at the restatement of it in 2024, when you look at those papers, there is a specific correlation between testing, lot sizes, and the safety and the results of those batches that are tested. And that is simply not true what Mr. Adler said. I think it's interesting that he states that the logic for the 5-pound lot size came from a Home Depot bucket. From a Home Depot bucket in Colorado. That's where it came from. If you recall, the BOTEC came out with a paper for the Washington I-502 project in 2013. That is where the state took its analysis from in determining the 5-pound lot size. It was not from a bucket in Colorado. Okay, I want to be very clear on that point. We relied as a state on actual scientific evidence in making the 5-pound lot size. And if you have questions about that, you can direct them to staff, because I know that we worked on that and that's 100% accurate. I want to point something out about the petition. And one of the things that Mr. Adler said is, he said that, he gave the story of a guy who came in and said, hey, GTI, can you have more cells for us? Right? I pulled GTI's, Green Thumb Industries, Form 10Q for the quarter ending June 30th of 2024, because I was curious as to how they did, right? GTI has increased their cash equivalents and investment position from 185.8 million to 220.8 million, gaining 35 million in fair measurement value. Their gross profit margins increased to 54% for the 3 months ending June 30th of 2024, compared to 50% for the same period in 2023. This is about GTI continuing to make money, and that's what they do. Corporations, their job is to make more money for their shareholders. And this is an area where they've said, look, I wonder if we can make more money doing this. And it's very clear to me that they just posted a record quarter ending June 30th of 2024. Their financial situation should be taken into account here when determining what regulations this board is deciding should implement or not. We have to remember who's asking for it and why are they doing it? Is it for safety or is it for money? GTI reported annual revenue of 1.5 billion and a gross profit of 528.5 million in February. I propose that GTI could pass some of those profits back to its customers through more sales. I think that would be appropriate. The BOTEC paper makes the argument, and when you read through the BOTEC paper, and I'll be honest, guys, I'm not a scientist, right? I'm a lawyer. And so for me to try to understand the science is difficult for me. But the science is there and is clear in the paper that shows, in multiple papers, that show why 5-pound lot sizes are safer, better, and the best standard for the safety of our community and our state. I think it's interesting too that there's been comments made about the whole industry wants larger lot sizes. Those have kind of been, now Mr. Adler did say, hey, I don't represent the whole industry, but it's inferred in their petition. I represent multiple small cultivators who are in opposition to this. I have 4 cultivators that I talked to yesterday that are all in opposition to this. They want to keep the 5-pound lot size because if they are testing at 20 or 50 pounds, as he suggested, and they lose a lot, they're done. It's over. GTI can fund, if GTI loses a 25-pound lot size, they've got enough money to cover that. It doesn't impact them long-term, but it does impact the smaller cultivators here in Nevada, without question, especially those that are not vertically integrated. And just for the record, those cultivators I talked to expressly said, please don't share my name because I don't want to get blackballed, right, from these multi-state operators that, you know, the big boys that have all the money. So I think that the board should consider the impact on the smaller cultivators and the smaller operators here in the state, not just the large MSOs. So in focusing on the opposition now, this is basically the same petition that came forward in 2022. And those board members that were on the board at that time, remember my arguments then. The same arguments apply now that applied back then. The difference is we actually have additional research and scientific testing from a reputable, a reputable company, Botech, that says that it supports its 2013 5-pound lot sizes and reemphasizes it again in the 2024 report. And I'll get to your question. Actually, I'll answer it right now. So if you go to the report and answer to your question, page 5 of the report on the overview, second paragraph, and I'll read the last sentence in the second paragraph. I mean, the whole thing talks about it, but the second sentence in the last paragraph says, 10 years later, the industry is much larger. States are seeing value in preservation of small businesses, and research does not show a scientific basis for changing the 5-pound lot size. There is no scientific basis for changing it. I would encourage you to, I won't go through everything, but pages 14 through 19 of the report actually explain the scientific analysis and research as to why 5-pound lot sizes are best practices. When you go to the conclusion on page 29 of the report, the conclusion and recommendations from Botech, last paragraph, the priority in testing cannabis and cannabis-derived products should always be public health and safety. Lot sizes should not exceed 5 pounds and at least 0.5% of the lot should be tested. Right there, black and white. I think that the science, Botech has a 40-year history of advising governments, states, different organizations, public institutions, educational institutions. They are the preeminent scientific, they're one of the preeminent scientific entities in this space, and relying on their science, I think the board should take it highly into consideration. I do have with me today many owners and scientists from the laboratories. I'm not going to have them speak because, again, I told you I wouldn't go for 3 hours. But if you have questions related to the science, I do have scientists here today that can answer any specific questions related to science if I am incapable of answering them. I'd also like to point out that larger lot sizes do jeopardize public safety as there is an increase in less accurate testing, which is again in the science of the materials. And only testing, so let me go to the next parts of the petition where he argues, the petition argues that you should only test finished products. This without question is a danger to public safety. There is, when you look at all the research, and again, it's in our petition, I won't go through it, but think about just simply food preparation or pharmacopoeia standards. You're doing testing, you test everything along the way to make sure there's nothing wrong with it in order to ensure safety for the end consumer. And that's standard across almost every single industry, from steel making to obviously up to food. Aspergillus kills people. There's a reason we test for it so that we don't kill people. I don't think we should get rid of aspergillus testing. The other danger is that larger lot sizes increase the probability of potential collusion within the industry. It's a big problem, right? I know this board, if it recalls years ago, we had some problems with that. It's been in front of the board a long time ago. I think we've gotten through that as an industry and everybody's doing well. But if an entire company's survivability is dependent upon one test passing or failing because you've increased the lot size, that's a problem. It opens the door for those issues. And for those reasons, I strongly suggest and recommend that you deny the petition. With that, turn it over to Kim.
Is it okay if I proceed?
Yes.
Thank you. Good morning, Madam Chair, members of the board, Executive Director. For the record, again, I'm Kimberly Maxon Rushton with the law firm Cooper Levinson, appearing on behalf of the Citizens Public Safety Alliance. As you've seen in the letter that I submitted to the board earlier this week, we are requesting that the petition be denied. And specifically because of the fact of the issues you discussed earlier, and that is the legislative blackout period that occurs on July 1st of an even year and extends through July 1st of an odd year. There is a specific reason for that. And it's because the legislature has said that administrative agencies and the Legislative Council Bureau must focus on the legislature. That's where your time and your resources go. Every time you open up a reg workshop, you have to pay for it as an agency. You have to hold workshops, which costs you money. So if you adopt this as a temporary, and we go through the workshop process, then we have to come back and do it again at the conclusion of the legislative session. Now this agency has spent valuable time and resources reiterating and considering a matter that you considered once in 2022 and rejected. You considered again in April of 2024 and rejected. It's not to say that there's not an appetite for considering this. You've certainly heard the dialogue today between the petitioner as well as the scientists in the labs as to where there are the differences in the understanding and why they're so stark. I mean, we claim in the lab are scientists. You mandate that these labs have PhD or the equivalent of individuals that have extensive scientific background. But you don't want to dismiss anything that would further the interest of the other aspects of the industry that would help them. And that may be a modification of the lot size. But you can tell just from the testimony today how extensive those workshops are going to be. So the requirement is that if you approve it, then you have to set up the reg workshop process. That goes through LCB first. Then you come back and you have a mandatory statutory obligation to hold a minimum of one workshop. This will never be accomplished in one workshop. You could just tell. And then thereafter, you have 30-day noticing periods. It goes back and forth to LCB. And again, the legislative intent is very clear. This time of year is to be focused on the legislature. If the petitioner wants to go to the legislature and propose this to them, he's more than welcome. I guarantee you that what would happen is that those legislators would look right back to you and say, you're the experts. Take it to a reg workshop. And that is where it should be. But now is not the time. The time it will be following the conclusion of the legislative workshop or the legislative session to see what, if any, other changes are made to the composition of the CCB, the statutes that govern the industry. There could be a multitude of changes that would otherwise make this moot. That's why you don't open up a reg workshop at this time. It certainly doesn't rise to an emergency. And it doesn't necessitate a temporary, and again, the expenditure of time and funds from this agency when you have other things that you need to accomplish. I don't disagree with the idea of possibly moving into an advisory committee because again, it would continue the dialogue and that's what I think the objective is today. But it certainly doesn't warrant opening up a reg workshop for this. So for those reasons, I would respectfully request that the petition be denied based on the clear legislative pronouncement that administrative agencies not move forward with the adoption and repeal or promulgation of new regs during this period. And as always, I'm happy to answer any questions that the board may have.
Thank you. Okay, any additional public comment?
Sir, can I ask questions or no, because this is public comment?
Well, it's pretty much public comment, but maybe at the end of the public comment, if there's some questions that somebody might be able to answer. Otherwise, like we said, we'll probably be here for a very long time. And I mean, I want to take the appropriate time because this is important and we don't want to just rush to conclusion without having heard everybody. But so I guess I leave it up to you. Member Durrett, do you think this is something that these members of the public can answer, or do you think you want to hear everything out before you ask questions?
I'll take it down from 5 questions just to 1, because it is, I do think, something that I'd like the future commenters to address if there are labs testifying, speaking. I would like them to point me to the place in the report where it says that we should stay at 5-pound lots, not in the introduction or the conclusion. In page 14 to 19, it goes over a lot of information about sampling, homogenization, a lot about cannabis in general. And I know I understand exactly what it's saying about maintaining the sample size. So if they could point out to me the exact paragraph where I could get the information that I think actually the way Kara expressed it was that the best, that there is a if you stick with 5 pounds, then you're going to get consistent results at to a statistically relevant degree. That it's been shown that if you go beyond the 5 pounds, that consistency starts breaking down. So where does it say that? Just point out the paragraph to me. That's it. And maybe it'll be a lab that needs to do that.
I have some points. This is Kara Cronkite for the record. There's just some, I can't point you to the exact pages for all of this because I just cut some notes and pasted them, but the heterogeneity of the variation in THC between the buds and contamination, it can't be mixed away is what they said. For this reason, the lot needs to be sufficiently small enough to collect a representative sample. The larger the lot size which the sample is collected, the larger the grouping and segregation error, also known as GSE, becomes. It says, the study looked at the ability to demonstrate precision, accuracy, and reproducibility over time using cannabis samples from California. 1-pound lots were tested in the study. 5-pound lots were settled on based on approximate yields of cannabis in indoor grows and balance between representativeness and testing costs. The 5-pound lot size is based on sound sampling methodologies aimed at ensuring that the potency and purity of the lot can be inferred from test results. As you increased the sample weight, the variability was reduced, but at a certain point, cannabis is just too heterogeneous for one number to encompass all within an acceptable range of variability. They also looked at the acceptable quality level, AQL, which is a statistical measurement of the maximum number of defective or contaminated or inaccurate goods considered acceptable in a particular sample size. And then I have a quote, the extent of variability in cannabis is not infinite, and at a certain point, there are diminishing returns of reducing lot size. Required methods of gathering lots and retrieving samples must attempt to reduce variability, and any opportunity for the results to be manipulated while keeping down the cost of testing. But on page 21 of 26 in the 2013 BOTEC, the second to last paragraph, the bottom 2 paragraphs are really where they get into the 5-pound recommendation. So it says the suggested amount for a lot of plant material is not more than 5 pounds based upon the approximate flower yield from an indoor grow facility using tables. And then it goes on about grow situations.
So in the 2022 BOTEC report, did they test anything above 5 pounds?
I believe they were, Kara Cronkite for the record, I believe they were testing 1-pound lots and extrapolating the data based on that.
Okay, because I don't understand then how they established that going above 5 pounds negatively impacted. I mean, they compared, I guess they did that by comparing 1 pound to 5 pounds, and then they didn't go beyond 5 pounds. So it's pretty limited in scope.
They were looking at, let's see if I can find it here. They were looking at the relative variability, and as you increased sample sizes or the amount of samples taken, and the variance between each sample. They were saying, okay, well, if you have fewer samples taken or more samples taken, there's a curve that they show in figure 4 in the 2013 BOTEC, where they show the geographical representation of variability with samples.
I think I'll leave it at that. I have a bunch of questions and comments, but I'll leave it at that to keep it going along. But I think that's a good example of why we need to discuss further, because I do want to ask all those questions, but I won't today. Thanks, Chair.
Thank you. Any additional comment? Okay, thank you. Additional public comment from the South?
None here, Chair.
Okay, thank you. Any public comment in the North? No public comment in the North. Is there any public comment online?
If you wish to provide public comment, dial *9 to raise your hand. We have 2 people for public comment. Caller with the last 4 numbers 2119. Go ahead.
Thank you. Please state your name for the record and limit your comments.
Dial *6 to unmute.
Hi, good morning. Good morning, Madam Chair and members of the board. For the record, speaking, my name is Timothy Eli Addo. And I wish to address certain concerns from this just agenda from a public health and safety perspective for both consumers and cultivation employees in general. And I'd like to first begin with the lot size. And I do admire, just to put on record, I do admire Will Adler's presentation, and because it is quite a very interesting and important conversation to be had. So I'd like to recommend him for at least pushing this through. But I'd like to address certain issues. And the main question is why? Why in terms is the lot size a factor in this conversation? And simply, my best guess would also be, as previously said, it's simply about profit. Then most likely the follow-up question is how? And then I would like to basically touch that from a cultivator's perspective, simply if you're operating from a multi-state operator's perspective, pretty much there are numerous remediation techniques that are already available. That are already being, somehow implemented, right? That basically for post-harvest, remediation techniques. So that is already in process even before these samples are going to be tested by third-party laboratories. So they've already taken that precautionary measure to ensure that, most likely a positive result, most likely comes out of it. So that is the main reason why it's, the how it becomes a matter of simplicity, right? Because the bigger the lot, the more you can test. And then, you could, as long as you're pushing that whole, remediation, whether it's at the expense of the employees, because unfortunately, on some of these methods are not being, there is very little oversight too from the government bodies on how, on certain, protocols that are already being implemented in terms of the health and safety of the employees in general. So coming back to this, I really think maybe I'm out of time because I'm sorry, I'm speaking from a cell phone and I really cannot see. But yeah, I will continue my comments at a later time. I'm hearing noises on my phone, so I'm sorry. Bye.
Okay, thank you. There's one more caller on the phone.
Caller with the last 4 numbers 4185. Go ahead, dial *6 to unmute, and please state your name before providing your comment.
Good morning. For the record, this is Abby Kaufman. I wanted to point out on the record that in recent months, the board has kind of repeatedly and selectively opted to respond to public comments and has been kind of inconsistent in the 3-minute time limit. But that said, so I'm the executive director for the Chamber of Cannabis, which is a 501c6 nonprofit. And historically, we have members on both sides of this petition. So I want to make it clear, I'm not expressing support or opposition to the contents of this petition until we discuss with our membership in more depth. I am, however, opposed to the concept of the CCB denying petitions submitted by interested parties and denying them solely because of the timeline for the implementation of changes. I've reviewed the 22 petition, but this one is yet to be posted online. So again, we don't have it stamped. But on principle, I have concerns about using the APA process and that timeline as grounds for denying a petition. While it's a new process for the CCB, the petition process is not, and other state regulatory agencies have operated under the APA with their own set of regulations for petitions as well. And I'd be willing to guess that it is rare for those other regulatory agencies to have that be a factor in their decision for petitions submitted by interested parties. So from my understanding, if the petition is approved, this would kick off the APA regulatory process where the CCB would post notice, open a small business impact survey, conduct a workshop, then present these findings at a hearing. From there, the CCB would submit those to the LCB register. And I recognize that the Legislative Commission has yet to review the LCB files submitted from back in June, and that the upcoming legislative session will lead to a prolonged waiting period for anything approved by the board in the interim. But did just want to express that doesn't seem like a good precedent to set for a factor in evaluating a petition moving forward. Thank you.
Any additional public comment?
There's no additional online comment.
Okay, I see somebody down in the south. Is that a public comment in the south?
Yes, Chair, additional public comment.
Okay, please identify yourself for the record.
My name is Abdul Mikibai. I am PhD in analytical chemistry with 36 years in this field and also a biochemist. I worked for the government for over 25 years, and I am scientist consultant now. I don't own business or work for any labs or present in any labs. I am just talking as scientist. I hold a bunch of paper in contamination for pesticide. And with my experience, I want to give you my 5 cents opinion on this. The lab can be accurate no matter what lab. The accuracy of the lab is depending on the samples. And with my experience, I worked with air samples, water samples, food, soil, biological samples, and cannabis sample. They are the most challenging samples to work with. The reason why, because they are not homogeneous. Not 2 plants are the same. So for someone to test 1 plant or few plants or couple plants from a bigger room, the result won't be the same. The reason why, if couple plants at the end of the room getting less water, less sun, they will be contaminated at least with common thing, it's mold. So the smaller lot size, the more accurate and representative of the samples. For cannabis, if we could mix all the sample and homogenate them and grind them and stuff, then we have representative sample. But in this business, they can't because they are selling the sample as bud, which is, if you have larger sample, 2 labs or 3 labs, they will not get the same result because of the variation. Other states, they started with larger size and they went to this route going for starting with medium size or smaller size and to try to save couple bucks going for larger size, and they learned the hard way. Now they are coming back to smaller size. And in my opinion, we cannot save couple bucks on the expense of the safety of the consumer. And many states, they had recalls for products for this reason. And the golden standard of the state of Nevada proves that the program is working. It's not 100% perfect, but it's working. Especially, like I said, if I could put 1 pound size, because that will be very, very representative. 5 pound size, and also the sampling is problematic. You have 5 pound size already a lot, and you go sample, you don't mix all of them to take samples. Now you have 10, 15, 20. How you are going to do that? Variation will increase. Safety of the consumer will be, jeopardized. And the variation of the results between labs, it will be bigger. And all of them, they are doing accurate, testing, but the sample is different. So this is my, like I said, my 5 cents scientific information. That's, and I believe, and another thing, if bigger large size fail, the cultivator will be losing a lot compared to 5 pounds lot. It doesn't make sense to me. And like I said, the most important thing is the safety of the consumer. Thank you.
Thank you. Any additional public comment before we let the petitioners have a final say? And we'll bring it back to the board for a vote.
Will Adler for the record.
Tiffany Newburn Johnson for the record. Oh, you want me to go? Oh, okay. So I just want to address a few points. One, it was mentioned that the 5 pound lot size is the standard. And just want to point out that if that is the case, then why aren't 38 states using 5 pound lots? I think that's pretty obvious. The other thing I want to address is the BOTEC report. The BOTEC study doesn't imply that we'll be more safe on issues. It doesn't give no more scientific evidence that you should use 5 pound lots as opposed to not. And I think that that's something that we need to fully flesh out and discuss. The third point I want to discuss is we don't dispute that smaller cultivators should be able to do 5 pound lots if they choose. We're not asking for a mandatory maximum. We're just asking to increase the maximum for those that do think that their products would be able to, their harvest will be able to meet that larger size. If a cultivator would like to submit 5 pound lots, we think that they should be able to continue doing that because, if they have a smaller harvest, that makes sense. And that's why they have craft cultivation. So, with all of that, we're just asking for the board to approve, to continue this discussion, and understand that the timing, is a question on everyone's mind. But we think that if you approve, continue with this discussion, workshops, that is a good faith effort from the board to really talk through the issues at hand here.
Will Adler again. I just wanted to ditto most of Tiffany's comments there, but as we heard, there is a vast difference in opinions in the Nevada cannabis market today, and that is exactly what I want to try to bring forward and identify in front of the board for everyone, because I do feel that this is exactly the role that the board of the CCB can fill, is bridging that gap and finding that middle, or becoming the beginning of that conversation, because this is something that affects every single person in the industry, and every person who buys cannabis from us is ultimately affected by lab testing and the efficiencies around it. There's a lot to be said about what is, standardization or best practices. But as Tiffany said, 36 states don't use 5-pound lots today. I do think that leads us towards saying that can't be, the strict and fast best across the nation, because the nation isn't doing that. But we don't know what is the best number in Nevada. And I want to encourage to say, we would appreciate the board's input. We would appreciate staff's input and direction from that data, because ultimately this is the whole state and our whole industry that needs to adopt this and change. But we'd like to continue that discussion in any way you guys see fit. But thank you for hearing us today. And if there's any additional questions, please let us know. Thank you.
Thank you. Any questions, any final questions of petitioners before we bring it back to the board for a vote? Okay, let's bring it back to the board. Any discussion before I hear a motion?
Member Drat, I want to make a comment that doesn't really, I think, cut either way, but the comments that this is just about money and not public health, I think, are not necessarily accurate, because this last legislative session, the legislature revised our preamble to specifically point out that there is an illegal market issue that exists in this industry, unlike many other industries, and that we have to carefully balance what we do to protect public health, to not have the counter effect to move people to the legal market and threaten public health that way. So I think we have to, we forget it's out there, because we're not all buying, because none of us are ordering illegal cannabis. So we forget it's out there, but that is a big factor we have to balance. Thank you, Chair.
Thank you. Okay, we have this petition before us. There are different avenues that we can take. We can grant the petition as is, then we would begin the rulemaking process during a legislative session, or about to be a session. We can have some other avenues, including advisory committees, commissions, subcommittees, what have you, to listen to and vet this out. There might be another option for approval, or if we deny this, we can deny it with prejudice, means that it's done. Without prejudice means you can bring it back. But either way, when we make our determination, we have to lay out the reasons for our determination, because that is that's the protocol that we have to do in order to write an order that comes down, because we're quasi judicial in nature. So with that said, I'll entertain a motion, unless you want to have some discussion before a motion, or if you have any additional questions.
Sure, Member Drat, I'm open to whoever the rest of the board wants to handle it, and what's most convenient for staff. I would like us to hear it in any capacity before the legislative session to get have more thorough discussion on the science, but I'm open to whatever the board wants and thinks we have capacity for.
Member Mazarano agrees with Member Durrett. And maybe Chair, could you make the motion?
Make the motion in what I'm hearing from both of you is that you are in favor of continuing the discussion with regard to lot sizes and testing, aspergillus testing, which we didn't get too much into it, but a little bit into. I think there were 3 topics that the motion touches on. And I mean, personally, and I'm going to put it out there, personally, although I do think it deserves more discussion with the science, with more science behind it. And I know we've talked to other states to get their comments to find out how they feel about larger sizes. 2 of them that I think I read about, but maybe we need to talk to other states, those 38 states that the petitioner speaks of. But I just think at this time right now, having come off the April discussions and having and I was not there, but from what I understand, these items came before the board and there was discussion on and there was public comment. And the fact that the board did not take it upon themselves to put those regulations there or change the regulations makes me think that it's premature. And so I would be in favor of denying it with prejudice and having it come back when there's more documentation, more science. I mean, without prejudice. Without prejudice. I'm sorry, did I say with prejudice? No, I meant without prejudice. Denying it without prejudice. And the reasoning behind it is just the number one, the timing and the documentation behind it. And I would also like the discussion to continue, but it sounds like if we have it continue in an advisory manner, then it really doesn't get to the heart of it, which is what the petitioner is asking for. And the petitioner, ultimately, you're asking for a rule change. Yes, you're saying, let's discuss it, but I mean, you're not going to be happy if we're just going to discuss it and nothing gets done on it. You want regulation change. And for the regulation change, I'm of the position that right now is not a good time for that regulation change because it's going to be a whole lot of wasted time because we can't really do anything about it until next year. So, yeah, if you want me to make a motion, I'll make a motion. And my motion would be then to deny it without prejudice.
Chair,
Yes.
real quick, board counsel. Deputy Attorney General Joseph Ostunio for the record. So if you guys were to approve it, there's nothing that says you have to adopt a regulation. And the only time limit that starts is when you submit it to Legislative Council Bureau. And then there's 2 years for the board to adopt the language. So if you guys were to approve it, you don't necessarily have to change the regulation and you can keep the discussions going, get more evidence, and then decide then whether you want to adopt a new reg. So I don't want you guys to feel like you can't approve the petition based on the legislative session. That's all I have.
But then would denying it without prejudice would have the same effect too?
Yeah, to a degree, yeah.
Still be extended period of time.
Bucks difference, but.
Well, and I just want to clarify that because I was under the impression that if we approved the petition, which is basically a petition for the regulation process on these items, that once we approve it, once the order comes down, then we have to start the regulation process. And don't we have to put a regulation, put a notice out within a certain period of time? I thought the clock started ticking.
you have to initiate the regulation making process, but that doesn't mean that you actually have to approve a regulation, under my understanding. I spoke with the chief deputy, and she is under the impression that you do not necessarily have to adopt a regulation, but you do have to start the process. I don't disagree with that.
Okay. Well, I'm gonna make that motion and see where it goes, because not that I'm counting votes or anything, but I think at least two of them would not be with me. So my motion then would be to deny the petition without prejudice, with the reasoning behind it would be that it's premature with regard to the evidence that we would need to begin the rulemaking process, and also that it's moot at this point in that it's been before us once and it was denied, and that it was just vetted in April of this year. And and Adler's shaking his head that it was not vetted, but this is what the evidence that I heard today was, that it was vetted and that lot sizes were vetted.
Allowed to speak at this moment? The correct function.
Well, I'm in the
Okay.
middle of a motion, so let's see where my motion goes. And those would be my reasonings based on the information that I have heard today and the testimony that I've heard today. The science behind it doesn't, in my opinion, and I'm not a scientist, just what I've read and what I've listened to, does not support your petition to increase lot sizes and to change the testing for certain microbials. So, and again, I'm not a scientist, so if anybody wants to correct me in my language, please feel free to do so. But that is my motion, and we'll see if it dies for second or for the vote.
Chair, I'll second. I don't want to take the whole agency kicking and screaming into a workshop on this while they're getting prepared for a legislative session, because I do think the petitioners will have plenty of opportunity to address this at the legislative session, and maybe that is where it's more appropriate. They did get a preview of a lot of the just talking points, and hopefully the parties can work on it together. So I would have liked to see an agendized workshop or CAC meeting, but I don't want, I know staff has to prioritize, and I do think all the parties are going to continue to work on this. So I would second it, and specifically also because it's without prejudice, so they could come back again.
And Mr. Adler, I don't want you to think that this was a waste of time. It's not. It's open to my eyes, because I don't live with this every day, and so I think the more that everyone comes to the board and brings these items before us, it educates us, and it at least me, and I'm able to understand things a lot better. And so we have a first, we have a second. Is there any discussion on that motion?
Member Douglas, for the record, I can't support the motion as it presently stands. I'm concerned that we will not have the best evidence available during the legislative session. I'm concerned that the legislature is not limited. They can take this up on their own with or without information and do whatever they want to. And they only have our outdated study at some point from prior, and anything new that's offered. That's my reservation about us not officially doing something. Understanding from the information provided to us by legal counsel, that time period doesn't begin to run until we submit something to the Legislative Counsel Bureau. So it would allow for hearings and gathering information, but it doesn't mean we're necessarily going forward. That's my reasoning for not supporting the motion.
Thank you. And those are good points. And so we'll see if the motion fails, then I'd be happy to take your motion. Any additional comments on the motion? Hearing none, all those in favor say aye. Aye.
Aye.
Is that two? Okay, any opposed, say nay.
Nay.
Okay, you guys are in the room. Will you please do the count?
Yes, Chair. James Hum for the record. The three ayes were yourself, Vice Chair Jarrett, and Member Merritt. The two nays were Dr. Mazarana and Justice Douglas.
Okay, so the ayes have it then.
Correct.
Okay. Thank you, and I know that we haven't heard the last of it, and we'll see what happens after this.
Thank you, Chair, and I do appreciate the discussion we had, but I would hope that even though we were denied with prejudice, that staff could independently take.
No, without
prejudice. 2 for 2, nailed it. All right.
You can bring it. You can bring it back tomorrow.
Won't tempt me, but yeah, no. I do hope that this stimulated the discussion, as you said, and that we could get some direction to staff to have a industry-wide survey developed to have these data points go forward, because I do think this discussion will continue outside this room and beyond, and having that knowledge of what the industry actually desires, what there is to benefit from this, and what harms could be found, could all come through the data-driven processes that the CCB could provide us with. But you know, I won't speak to further comments or declarations from here, but I would say it is our hope that you heard us today, and that you understand that there's a further discussion to come on this. So thank you.
Absolutely. Thank you so much.
Yes. No, I just want to say thank you very much to the board. Appreciate you all listening to us today. And again, you know, we would be happy to bring this forward again to continue these conversations. So thank you very much.
Thank you. Our next petition is going to be enclosed, and so we just need some time to clear the room. There is a final public comment at the end, and a couple of housekeeping items, but other than that, we'll be back in about 5 minutes. Thank you.
You didn't? I'm surprised. Short. Yeah.
Is that correct? Protocol?
Yes.
Yes, okay, perfect. All right, we're gonna go ahead and open up the room, and we'll open it up for a vote. We just have to do that in open public meeting, so we can't vote in closed doors. We can talk to you about all of your personal stuff and everything with regard to your matter in closed, but then we have to open up the room to vote.
Sure.
Okay. So we're open up here now, and you guys let me know when you're open in Vegas.
Door is open.
Okay, so Member Durrett, do you want to restate your motion?
They opened it online?
It is.
Okay.
I move to approve today's petition with the condition that it is confirmed by the employer in writing that they would like to employ the petitioner either through an email that we initiate or they initiate. And that would be the only limitation. Thanks.
We have a first, do we have a second?
I would second the motion. I just, to the writing, just verify that it's.
Yeah, I'm sorry. Can I modify the motion that it's just that staff understands that the call is from the employer, or the communication is from the employer. It can be a call, speed it up, but as long as they verify that it is actually the employer.
Okay.
Member Mazarana seconds that.
Okay, we have a first, we have a second. Any discussion on the motion? Hearing none, all those in favor say aye. Aye.
Aye.
Any opposed? Motion carries. Congratulations and good luck to you.
Thank you, guys.
All right, take care.
Thank you.
Okay, so we're on to item 9, which is the briefing from the chair and the executive director. I don't have any official briefing, so I'll just turn it over to the executive director.
Thank you, Chair. James Hum for the record. I'll keep this brief. It's been a longer meeting today, but just wanted to let the board know, as well as industry, as well as the labs, that we are committed to continuing this conversation. So I believe that was ultimately the petitioner's goal, was to keep this going, keep this dialogue open. So I will make a personal commitment on behalf of myself and the team that we will continue those discussions, especially as we're heading into a legislative year. So although the process won't necessarily be formalized based on the vote today, I can assure you that we'll continue to diligently look into this, looking forward to additional studies, looking forward to additional conversations with all interested parties. So that's just kind of what I'll address on that. I'm sure Mr. Adler will find me when he wants to chat. So I don't think that will be an issue. So again, thank you to the petitioner for bringing that forward today, as well as the labs for voicing their concerns. So this is just completely a housekeeping item. Our office sent out communication regarding the October 15th deadline as we introduced the Nevada CCB item catalog and metric. All existing items and metric will be grandfathered in. However, they will be required to have all necessary updates, including photos, allergens, and ingredients. After this date, items input into the item catalog will require review and approval. Thank you to all who have provided invaluable feedback during this time. Please continue to keep lines of communication open with the team, and that's at auditinspections@ccb.nv.gov. Again, if you have any inquiries, please send those to auditinspections@ccb.nv.gov. That's all I have, Chair. Thank you.
Great, thank you. Our next meeting is October 17th, 2024. And items for future agendas from the board members, any items for future agendas? I think I just have the legislative policy that's coming in the next few months. But other than that, any other future items? And with that, we'll open it up to the final public comment. Public comment in the South.
Does not appear to be, Chair.
Okay, any public comment in the North? There is none. And how about public comment online?
There's no one online to provide comment.
Okay, and with that, we're going to adjourn our September board meeting. Happy to see everybody, and we'll see you